Okay, good morning, everyone. I've got 9 o'clock. I think we're going to go ahead and get started now. We're still waiting on one panelist to join, but hopefully during the course of the introductions here, we'll have that individual join. Thank you for joining us for the Medical Board of California Panel A meeting. Pursuant to the provision of Governor Gavin Newsom's Executive Order N29-20, dated March 17th, 2020, this meeting is being conducted via WebEx. Dr. Lewis, you can go ahead and start the meeting, and I'll start bringing in the judge and court reporter and everyone else, okay?
Okay, thank you, Sean. I'm Dr. Ron Lewis, Chair of Panel A of the Medical Board of California. Welcome, everybody. The first order of business is to call the roll to establish a quorum. Would you please call the roll, and each member should state their name.
Dr. Hawkins?
Dr. Hawkins here.
Ms. Lubiano?
Present, Lori Rose Lubiano.
Dr. Tirado?
Present.
Mr. Watkins?
TJ Watkins, present.
Dr. Yip?
Dr. Yip, present.
Dr. Lewis?
Dr. Ron Lewis, present.
We have a quorum.
Thank you very much. The next order of business is to elect the panel chair and vice chair of Panel A. So I'd like to take nominations for Panel A chair. Do I have any nominations? Dr. Yip?
I'd like to nominate Dr. Lewis.
Okay, I accept. Any other nominations, since I can't see you all?
This is TJ Watkins. I would like to nominate Ms. Labiano.
Okay. Ms. Lubiano, do you accept?
Yes, I accept.
Where is she? Okay. Any further nominations? Nominations are closed. So we have myself being nominated and Ms. Lubiano being nominated. I think the best way would be to call the members, each state your preference. So that's probably the best way to do it. So let's call each member, please.
Dr.
Go
Hawkins?
ahead.
Dr. Hawkins?
Dr. Lewis.
Ms. Lubiano?
I vote for myself.
Okay,
Dr.
next.
Tirado?
Dr. Lewis.
Thank you.
Mr. Watkins?
Ms. Labiano.
Dr. Yip?
Dr. Lewis.
Dr. Lewis?
I vote for myself. Is that it?
That's it.
Okay. So 1, 2, 3, 4, and 2. Okay, thank you very much. And elected Panel A chair for the coming year. Next order of business will be to vote on the vice chair of Panel A. Do I have nominations? And I'm going to nominate Dr. who's been doing it for the past year.
I understand you, Ron.
What?
I understand you.
Oh, can you hear me now?
Yeah, it just broke up on my audio.
Okay, I'm nominating Dr. Yip for vice chair.
Thank you. I decline. I'd like to have a public member to be the vice chair. I'll decline. I nominate Ms. Lubiano.
Okay, Dr. Yip declines, and Ms. Lori Lubiano will be nominated instead. So do you accept Ms. Lubiano?
I accept. Thank you so much.
Okay, good. Any other nominations for vice chair? Left, right, none? Okay, so Ms. Lumiano, well, we have to call roll, right? Yes, we have to call roll to make it official. So let's go call roll.
Dr. Hawkins,
Ms. Lubiano,
Ms. Lubiano,
Myself. Thank you.
Dr. Torado,
Ms. Lubiano.
Mr. Watkins,
Ms. Lubiano,
Dr. Yip,
Ms. Lubiano, thank you.
Dr. Lewis,
Ms. Lubiano. So it is I'm not hearing any objections. So congratulations, Ms. Lubiano, for being elected vice chair of panel A. Good. Okay, the next order of business is to hear the oral argument on the non-adopted proposed and I'd like to have the ALJ introduce themselves, please.
Good morning. This is Heather Rowan from the Office of Administrative Hearings.
Thank you for being welcome.
Thank you.
I'm going to hand the gavel over to you to begin the non-adopted proposed decision of. Thank you.
Thank you. Is there a court reporter on the line?
Yes, Your Honor. My name is Bryn Watford. Would you like me to turn my video on?
It's helpful to me. If you don't want to, I understand.
Let me see. Can you see me? It looks like it's trying to connect right now. Can you see me okay?
Yes. Thank you.
Of course.
Can I get your CSR number?
Of course. It is 14234.
Thank you. Thank you for being here today. Just sure you got the request, but we have 4 hearings. I'll stop in between each hearing to allow all of us to switch gears. So each record will be a separate record for each case. Is there an Attorney General? Mr. Tan, I believe. Mr. Tan, are you on the line?
We did an audio check with him earlier, Judge Rowan. Jansen, are you available? Your phone might be on mute I can see your WebEx is on mute. There we go.
There we go. Sorry about that. I was trying to figure out the video, Your Honor. I apologize. This is Deputy Attorney General Jansen Tan for the complaint.
Okay, thank you. And I understand Mr. Giardina will be representing Dr. Bloom. Are you present?
That's correct, Your Honor. We seem to be having some difficulty with my video and upgrading me to a participant, according to Sean. So I want to make sure that you all can hear me.
I can hear you. Mm-hmm.
Yeah, unfortunately, I'm not able to upgrade him to be able to share his video. I'm not sure exactly what the issue is, but we were able to test with Dr. Bloom yesterday, so I believe his video should be available.
Okay, and
It is.
I can hear you just fine, Mr. Jardina and Dr. Bloom. Are you? Is Mr. Jardina? Is Dr. Bloom also with us?
Yes, I'm here.
Okay.
Yes, I see him.
Thank you. Okay. All right. So I'll take us on the record and just give a brief overview. These video hearings and audio hearings can be a little difficult in the way that we engage with each other. So I want to remind everyone, if you're not speaking, to have your microphone on mute. And if you are answering a question, if you wait briefly for the end of the question before answering, we can try to avoid speaking over each other and give the court reporter a little bit of help in not having more than one person speaking at a time. Okay. Dr. Bloom is our first petition. When we go on the record, I will remind the parties of the timing. I will keep the time, which means that I will be interjecting as we go along to let you know how much time you have remaining. Okay. Ms. Watford, are you ready to go on the record?
I am, Your Honor, yes.
All right, thank you. Here we go. All right, let's go on the record, please. We are on the record before the Medical Board of California in the matter of the accusation against David A. Bloom, MD, Medical Board number 800-2016-028979, OAH number 2019-031074. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Heather Rowan. I'm an administrative law judge with the Office of Administrative Hearings. I have been assigned to preside over this hearing. Prior to going on the record this morning, we established that there is a quorum of the panel. As I'm saying that, I know that we voted. I'm not sure if I heard the roll call. So I'm going to ask the secretary to step in and call the roll to ensure that we have a quorum, because the video hearing makes it difficult for me. So I'm going to step back for a moment and ask a quorum to be taken.
Dr. Hawkins?
Here.
Ms. Lubiano?
Here.
Dr. Torado?
Present.
Mr. Watkins? Dr. Yip?
Present.
Dr. Lewis?
Present.
We have a quorum.
Thank you very much. I take the appearance for the Attorney General's office, please.
For the complainant, Deputy Attorney General Jansen Tan, TAN Tan.
Thank you. And for respondent.
For Dr. Bloom, Lawrence Jardina, Giardina.
Thank you. The board in this matter has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has invited discussion of whether the proposed penalty should be modified. The following process and time limitations will apply. Respondent will have 15 minutes to make an opening argument. The Deputy Attorney General will have 15 minutes for a response. Respondent and the Attorney General will have 5 minutes each for closing arguments. The time limits will be enforced. I will interject when you have 1 minute remaining on your time to remind you to come to your conclusions. These arguments are based on the existing records and shall not exceed the scope of the record of the evidence admitted. No new evidence will be heard. The panel members may ask questions to clarify the arguments, but not to elicit new evidence. At the end of the oral arguments, I will offer the respondent an opportunity to address the panel regarding penalty if he so chooses. If you wish to make any statements, I will take that statement under oath and I will swear you in. Following today's oral argument, the board will meet in closed session and deliberate. There will be no written decision today. You will receive it in the future. Is there anything that we need to address before we move straight into oral argument? Mr. Tan?
I have nothing, Your Honor.
Mr. Giardina?
Just a clarification, how long is Dr. Bloom allowed under your scenario?
I don't believe that there's a statutory or rule limit. I generally will take 5 minutes or less of that statement, and that's to address the proposed penalty.
Thank you, Your Honor.
Mr. Giardina, are you prepared to begin your 15 minutes?
I am.
Okay, whenever you're ready.
Good morning, Your Honor. Good morning to the members of Panel A. Good morning to Mr. Tan and to Dr. Bloom. This hearing here today is the result after a multi-day trial before an administrative law judge who issued a very detailed ruling based upon her consideration of the evidence. That includes not only the written documents, but evaluating the demeanor and the quality of the witnesses testifying before them. I think that it should be stated at the outset that the medical board has only asked that there be a discussion regarding the penalty phase of the judge's decision. The penalty phase is essentially in approximately paragraph 64 of her decision. All of the other matters regarding standard of care, I think that the panel should be aware of that isn't before them now. And indeed, Dr. Bloom and I reserve the right, once we have a final decision, to address those issues. So I would ask the panel, when evaluating this matter, to understand that there is disputes, those disputes relating to standard of care, quality of evidence, quality of experts, all of that is not before them. What is before them is to determine whether to change the decision of an administrative law judge who sat for multiple days listening to the evidence and who decided after, I think as you can tell by looking at the decision, we closed the evidence and it was months after we were preparing and submitting written concluding arguments before a decision was rendered. So it must be noted that this judge spent an inordinate amount of time not only listening to the evidence, but considering the evidence and preparing a detailed decision. So this was not done in a hurry. This was not done without a great deal of forethought by this respected administrative law judge. So just addressing what the administrative law judge found, she found that in Dr. Bloom's career, this is the only discipline that has been directed towards him for a single patient. This is not multiple patients. This is a single patient relating to a surgical complication, a known surgical complication during the performance of a laparoscopic cholecystectomy. This has been a long and fertile ground for litigation ever since there has been medical literature, which in a sense has created this litigation after saying that there's only certain ways to do a laparoscopic cholecystectomy safely, to identify the critical view of safety and to proceed. What the medical literature has, in a sense, done, contrary to the discussion and to the opinions of all the experts, is that it's essentially they have tried to turn this into if a complication occurs, then that means negligence. The administrative law judge, in looking at this matter, found some deficiencies in Dr. Bloom's technique. However, looking at the totality of Dr. Bloom's career with literally hundreds of other surgeries, literally thousands of other types of surgeries, she found that the most appropriate approach to providing the criteria which the medical board is sworn to uphold, which is safety of the public, that is not for punishment, in which I cite the case in my brief, that they are not here to punish. The role of administrative hearing is not to, in some manner, try to punish Dr. Bloom. It's to make sure that Dr. Bloom, going forward, will practice safely. So what the administrative law judge does in paragraph 64 quite clearly notes this is a single case in a physician who has been practicing at the time, over a decade. And that this single case resulted in a single complication. And Dr. Bloom has, since this complication, retrained in a fellowship in surgical critical care. Dr. Bloom has retrained and has undergone additional training. And we provided evidence of that to the administrative law judge. She is the one who listened to Dr. Bloom and described not only how he practices, how this occurred, and the retraining that he has done in order to make sure that he practices in a safe manner. In order to further that, she believed that a 3-year period of probation is appropriate and that he should have a practice monitor to make sure that his surgeries are being essentially reviewed to make sure that there isn't a problem with additional complications, and that would be reported to the medical board if indeed a practice monitor thought that there was a problem with his surgical technique going forward or with his surgical complications. She also recommended some education course and medical record course. The complainant has now said that they want to enlarge that to 5 years and add a complete examination at PACE or a comparable facility. I would argue that the medical board's approach does not do anything to add to the purpose of this whole proceeding, which is to make sure that the public is protected. There is no indication, and the administrative law judge was absolutely clear in her decision that 3 years is appropriate for probation, not 5 years, not 7 years, not some other term. And if you look at the complainant's brief, they spend a lot of time talking about the evidence, which is not before us, which is going to be before when we file further matters in this case. But what is before the board Now, what is before panel A? Should this be extended to 5 years? Should there be a complete evaluation of Dr. Bloom? The panel should be aware that Dr. Bloom continues to practice. He's continued to practice since the date of this complication. There are no further California Medical Board proceedings regarding his complication rate. So it seems that what the medical board has chosen to do by rejecting a very thoughtful, considered, and reasonable approach to what the administrative law judge has found. And I'm not accepting everything she says, but for the purposes of what panel A has to describe, she came up with a reasonable conclusion based upon what she found. The medical board seeks to enlarge that in what can only be viewed as a punitive measure. There's nothing about this case which indicates that a evaluation of Dr. Bloom is warranted or in any way protect the public. As we noted, this case complication occurred years ago, and he continues to practice. He continues to do surgery. And if the medical board had such a concern that he needed to be evaluated, that should have been part of their original accusation. That should have been part of their original approach multi-years ago. And at this point, to try to add that kind of let's say a week of his time and $30,000 to go to PACE to have that kind of an evaluation is simply unwarranted and punitive. The same applies to the 5-year request for probation. He is already been put on 3 years probation on top of the multi-years of his further surgeries since this case. It is absolutely unwarranted, again, based upon what the administrative law judge found and wrote in her opinion. Now, if there was some other evidence that they think she did not appropriately review, but they have not come up with something that other than it's a single surgical complication that's well recognized, that happens to every general surgeon at some point in their career. One patient, resulting in what she recommends is 3 years probation, practice monitor, and education courses. I would submit to the panel that given that scenario, in the setting of further training in a fellowship by Dr. Bloom, is more than sufficient to allay the purpose of panel A here, which is to protect patients, to protect the public. And there is nothing that I see in the complainant's argument that goes to that purpose, and that anything that they wish to add is simply punitive and is not allowed under the case law as put in my brief. I'm sure Dr. Bloom at the end of this will be wanting to expand upon the fact that he practices safely, upon the fact that he has one surgical complication that is before the board here, and that the further training that he has underwent, and that he may not agree with what the administrative law judge has decided. I don't agree with it, but that's not before us. That's something that we will deal with in the future. We don't have a final decision yet, and we argue and submit to the board that what's in front of them should be adopted as the final decision, so that Dr. Bloom can move forward and we can decide how to proceed. With that, I will submit my time. Thank you, Your Honor. Thank you for listening, boards members.
Mr. Giardina?
Yes.
Mr. Tan?
Yes, Your Honor.
Okay, you have 15 minutes.
Thank you, Your Honor. Members of the board, Mr. Chairman, Your Honor, Larry, and Dr. Bloom, good morning. My name is Deputy Attorney General Jansen Tian, and I represent the complainant in this case. First off, I would like to set some ground rules. Apparently, opposing counsel is mistaken. First of all, the order of non-adoption, and I quote, it states that the panel of the medical board will decide the case upon the record, including the transcript and exhibits of the hearing. That means that under Government Code Section 11517, the board is proceeding under paragraph E, which is they're rejecting the proposed decision and they're deciding the case upon the record, including the transcript. So it's actually, opposing counsel is mistaken that we're only supposed to focus on the penalty, even though the medical board panel wants commentary on the penalty. The transcript and the record is open to the board, to the panel to review the evidence. And I think that's crucial here because the evidence clearly states that 5 years is the appropriate penalty and pace is necessary to protect the public. I'm going to go into much detail. I don't disagree with the ALJ's findings. In fact, I think she made excellent credibility findings with regard to the experts. She identified the issue that respondents' experts never testified to the standard of care, and that is a fatal issue for the respondents because we have case law, which I cited in my brief, which states that in Doe versus Good Samaritan Hospital, 2018, 23 Cal App 5th, 653, it states that the expert testimony that provides that the standard of care was met without any elaboration regarding the applicable standard of care and what conduct was required to meet is legally insufficient. In Doe, the unrebutted expert declaration of a psychiatric nurse, which stated that the standard of care was met at all times, was legally insufficient because it lacked any elaboration regarding the applicable standard of care and what conduct was required to meet the standard. And this is exactly what happened in this case. Respondent's expert just said, oh yeah, Dr. Bloom complied with the standard of care without actually testifying to the standard of care in laparoscopic cholecystectomy. So that is one.
I'm sorry. Sorry, counsel, this is the court reporter. It cut out right when you said, so that is what?
Oh, which part?
Mr. Tan, before you continue, can I just make sure that everybody else is muted? I'm not sure where, there's a little bit of noise. I don't know where it's coming from. And Ms. Watford, do you want to see if you can figure out where he left off?
Yes, sorry, one moment. The last thing I heard, a respondent's expert just said, oh yeah, Dr. Bloom complied with the standard of care without actually testifying to the standard of care in laparoscopic cholecystectomy. So that is what, and then it cut out.
I can continue from there. So basically in Doe, the unrebutted expert declaration, which stated that the standard of care was met at all times, was legally insufficient if it lacked any elaboration regarding the applicable standard of care. And that's exactly what happened in this case. Respondents' experts never testified to the standard of care in laparoscopic cholecystectomies. So that is a major evidentiary flaw in respondent's case, which the ALJ pointed out to, that Dr. Dawadkov, complainant's expert, was the only expert that testified to the standard of care. With regards to the other issue, the board wanted commentary as to the propriety of a 5-year penalty, which is what our recommendation is. It's necessary to protect the public because, first of all, respondent in this case, as found by the ALJ, also as supported by the records, as I cited you in my brief, continues to this day insist that he did nothing wrong. He did nothing wrong. He still believes that CVS is just merely a view, despite the fact that all the experts, including his own experts, said that he was wrong. CVS, or critical view of safety, in a laparoscopic cholecystectomy requires 3 steps. And his definition of the CVS is incorrect. But despite this, in court, at trial, he stated, I did nothing wrong, and I'm still going to do my surgeries the way I do them. So that is evidence of appellant's irascible personality, and under Yellen versus Board of Medical Quality Assurance, 174 Cal App 3D 1040, the fact that he continues to insist that his method is proper despite overwhelming evidence to the contrary, in Yellen, the board actually revoked the respondent's license. In this case, because it is his first offense, we're merely asking for 5 years. And this is necessary to protect the public because respondent is stubborn. Sure, he did a fellowship, but it's an unrelated fellowship. He still insists to perform these laparoscopic cholecystectomies, CHOLECYSTECTOMY for the benefit of the court reporter. He still insists on doing this laparoscopic cholecystectomies without performing the 3 steps. Dr. Dawadgab testified, as supported by respondents' own experts, that the CVS is a 3-step process. Dr. Dawadgab is the only expert, again, to testify with regard to the standard of care, with regard to laparoscopic cholecystectomies, and he stated that the standard of care requires the 3-step CVS. The other reason why we need a 5-year probation and PACE and an ethics class, as we recommended in our brief, is because respondent is not a credible narrator of facts. Respondent made multiple inconsistent statements during this hearing. First of all, with Dr. Beneke, Dr. Beneke was the chief of surgery at Sutter, and also part of the medical executive committee that investigated respondent. He stated that Dr. Bloom, respondent, does not know about the CVS. He stated that, and this is a direct quote, so I want to get this correct. It's in the record, but basically, respondent stated that he cuts with one fell swoop. And Dr. Beneke found that the respondent didn't know about the CVS. He was clueless. But then subsequently, at the board interview, at the deposition, and at the hearing, all of a sudden, respondent says, oh yeah, I always do the CVS. But then, of course, we know that the CVS he's referring to is not the same CVS as referred to by all the experts in the field. His definition, even by Dr. Baker's account, one of his experts, said, I've never heard of it. And this is all in the record again. Moving on to the credibility of the experts. The ALJ found correctly that Dr. Dawadgab is the most credible expert. First of all, let me focus on Dr. Baker. Dr. Baker is not credible because he never defined what the standard of care is in performing laparoscopic cholecystectomy. Dr. Baker also admitted that respondent's approach to patient A's cholecystectomy does not identify what standard respondent was following, and it's not a recognized technique. This came from his expert, Dr. Baker. Dr. Baker also stated that he was not aware of the statements respondent made to Dr. Beneke. When asked about the respondent's statements that he cut in one fell swoop so that if there was an injury, there would be a nice clean transaction to repair, Dr. Baker explained he never heard of such terminology in training, nor has he ever used that language. Dr. Baker was also, again, not privy to the statements in the Sutter Executive Committee peer review report. This was withheld from him. So his opinion up to that point he did never even seen the conversation and the fact that Dr. Bloom's privileges were revoked, but before they were actually revoked, Dr. Bloom resigned. So Dr. McKeel, focusing on Dr. McKeel, similarly, Dr. McKeel was not given a complete set of records to review. She did not know about the statements made by respondent to Dr. Beneke. And as correctly found by the ALJ, Dr. McKeel's testimony is not persuasive since she inexplicably opined that it was clear that apparently respondent was not trained on the CVS, but somehow respondent nonetheless obtained the CVS based on the language he used in his operative note. So this was pointed out by the ALJ, but somehow respondent stumbled into the correct technique somehow, despite the fact that respondent admitted he's never heard of the CVS three-step process. So because of the credibility findings, because of the issues with respondent's inconsistent statements, because of the Yellen case that I mentioned regarding respondent's irascible personality and stubbornness to change technique, we're recommending 5 years probation with PACE. We don't know the issues with Dr. Bloom's skills. Dr. Beneke stated that he has a low index of suspicion with regard to potential injury. He found that Dr. Bloom's skills were lacking. Dr. Beneke is a percipient witness. He's not an expert. He's testifying as to what he observed during the MEC Sutter Medical Executive Committee investigation into the care provided by respondent. So, but his observations clearly state that respondent lacks training, which is why PACE is crucial. And I think the board picked up on this because you all wanted commentary as to the penalty. And a cursory review of the records, which you are allowed to do in this case because you're proceeding under paragraph E, clearly states and finds that respondent needs to be put under PACE so that his skills will be tested. We cannot roll the dice. We can't take his word for it. The medical board is the paramount protector of public protection with regard to the medical field. We cannot rely on respondent. He is not a credible narrator of facts. All his experts state that he was wrong about the CVS, and yet he persists, which is why we recommended 5 years probation, full PACE, supervision, practice monitoring, and that he be prohibited from performing laparoscopic cholecystectomies until we are sure that he is safe to practice medicine, specifically this procedure. That is all I have, Your Honor.
Thank you, Mr. Tan. Mr. Giardino, you have 5 minutes in rebuttal.
Thank you, Your Honor. I just want to make sure that you can hear me.
Yes, sir. Thank you.
So let me respond I think in a common sense approach for Panel A when you're evaluating this case. I've read the transcript, looked at every exhibit in this case multiple times, and it takes literally tens of hours to review everything, to review a very long transcript, to review deposition transcripts, to review interviews, to listen to interviews. There are, the Panel A would, and I don't know to the extent that you have put the time into it, but what Mr. Tan is essentially asking you to do is to accept and perform a cursory review of literally hundreds of hours between the hearing and the interviews and the transcripts, and to review every document and to substitute your judgment for the administrative law judge who heard everything that Mr. Tan just told you. She heard every last fact, every last issue that Mr. Tan attempted to highlight for you, and she decided, after sitting in judgment on this case, that 5 years was inappropriate, that a practice monitor was appropriate, that PACE was inappropriate. So what I would ask the board to consider, if Mr. Tan, after talking to this judge and putting on his witnesses, was unable to convince the ALJ, who was listening to everything, assessing, this was, it started before the pandemic was going, and the witnesses were there in person. She was able to evaluate everything that was said, cross-examination of each and every one of these witnesses, and she disagreed with Mr. Tan. I sat there and listened to Mr. Tan argue and read his closing argument where he argued strongly to the administrative law judge exactly what he told you. And she, sitting in judgment, disagreed with it. And frankly, I have heard nothing from Mr. Tan that impugns her decision. Her decision was well reasoned and protects the public. There is nothing that Mr. Tan has tried to add to any of this to say why she's wrong, other than she disagreed with him. Now, I could argue that I disagree with the ALJ on some of her comments and some of her decisions on evidence and expert testimony. But as for right now, we're accepting the record so that the panel can make a decision as to whether they should enlarge the punishment. I would submit that she decided in a single patient case with a single injury, a single complication in the face of someone who's gone on to practice for years without the medical board getting involved in Dr. Bloom's cases again, to recommend 3 years, a practice monitor, and education courses. I would submit there is nothing that Mr. Tan has said that the ALJ has not considered, and considered quite, as I indicated before, over the course of many months, and that there is no reason for Panel A to make the decision to enlarge the penalty. I would ask them to listen to Dr. Bloom when he speaks, and that, as always, the medical board has the burden, and that's why they get to go last, and that Mr. Tan will have 5 minutes after me. And what I would ask the board is that when you hear Mr. Tan finally speak, what he's recommending is that you do a cursory review of all these issues that he's brought up. And I would submit that that's unfair to Dr. Bloom and unfair to any physician in his position. Either you sit and take the place of this judge who decided on leniency based upon credibility, cross-examination, and that intangible view that she has of watching people and watching their responses.
Jardina?
I would submit
You have about
that basis.
30 seconds.
Thank you. I appreciate your honor. I wish you could see me. I would submit to the board that they should accept the ALJ's decision. Thank you.
Thank you. Mr. Tan, you have 5 minutes.
Thank you, Your Honor. The board's proposed decision clearly states that the proposed decision of the administrative law judge in the above entitled matter has been non-adopted. A panel of the Medical Board of California will decide the case upon the record, including the transcript and exhibits of the hearing, and upon such written arguments as the parties may wish to submit. This mirrors exactly the language under Government Code Section 11517, paragraph E. It's paragraph E because paragraph A to D, there are other options what the board can do, but the board decided to reject the proposed decision and decide the case itself upon the record, including the transcript. So it's misleading for opposing counsel to state, oh, ignore everything, and just follow what the ALJ found in terms of penalty. Again, I'm not contesting the factual findings of the ALJ. Everything is correct. The only issue that I have is the penalty, which this board can look behind upon. Again, under Yellen versus Board of Medical Quality Assurance, and this is a direct quote, appellant's irascible personality and the fact that he continued to insist in this case, it was injections and prescriptions were proper, provide the basis for the board's decision to revoke the appellant's license rather than imposing suspension or supervised practice. Again, the record clearly shows that respondent is unrepentant. At the hearing, he says, I did nothing wrong. I'm still going to do everything how I was trained, which is that the critical view is merely a view, not a three-step process, despite hearing from his own experts that he was wrong. Today might be a different story because obviously he wants a 3-year penalty, which they will then try to appeal. They reserve their appeal to try to whittle it down even more in Superior Court. So you might hear something different from him today. Maybe he's going to fall on his own sword today. I don't know. But what I do know is that in terms of protecting the public, we need to be sure. We can't roll the dice. PACE ensures that. He's going to take an exam. They're going to look at his clinical skills. Dr. Beneke commented his observation was that this guy, Dr. Bloom, didn't know what the CVS was, and he had a very low index of suspicion for potential injury. He transected the hepatic duct, mistook it to be the cystic artery, cystic duct, and he stapled the cystic duct, which led to complications for this patient, which is why 5 years probation is absolutely necessary. Again, Your Honor, and members of the board, I request that you all make credibility determinations, and it's all found by the ALJ as well, which I highlighted in my brief. It's crucial because when this thing goes up on appeal, because respondent does intend to appeal, those credibility determinations are necessary. All the inconsistent statements made by the respondent, as highlighted by the ALJ in her decision, all the credibility determinations by the ALJ hold true, again, with regards to the experts, and respondent's irascible personality, which is also in the decision of the judge. Again, the only thing that I don't agree with is the penalty. We need to ensure the public is protected, and the only way we can be absolutely sure is if respondents take that test. Not just the educational classes. Those are just like CLE.
You can?
Yes, Your Honor.
You're about 40 seconds.
In closing, Your Honor, I yield my time. We stand by our 5-year recommendation for probation and also the PACE program. Thank you.
Thank you, Mr. Tan. Mr. Giardina, did your client want to make a statement today?
Yes, he does, Your Honor.
Dr. Bloom, are you on the line? Dr. Bloom, if you're speaking, I can't hear you. Are you muted, maybe?
Yes, actually, I'm sorry. Apparently I was.
Okay.
So I clicked it.
Okay. Will you raise your right hand, please? Do you solemnly swear or affirm under penalty of perjury the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. I will give you 5 minutes to address the board. The board may have clarifying questions following your testimony, but other than that, your statement will be the last of what we hear today. I want to remind you that this statement is regarding the proposed penalty.
Yes.
When you're ready.
Good morning, all. So Mr. Tan wants to make this even worse for me than it already is. He didn't manage to leave out the part that Dr. Beneke, who he claims derided my ability, is the one who gave me privileges less than a month before. So he knew quite well how I operated. He also claims to deride the testimony of the experts and seems to believe that the critical view of safety is the absolute gold standard for this case. Even though the gentleman who described it in the first place in our submitted evidence says it's not the only way to do the case. And as I also said at the trial, I have no issues against doing that third step that he wants me to do, just does not need to be done. It does not need to be done in every case, as Dr. Strasberg says. The judge heard all of this. She read all the evidence. She's made her decisions. You've empowered her to make these decisions. I would say that if you keep deciding that to impose harsher sanctions, I, as of now, given my 3 years of experience, would not be able to go up to any hospital in California, let alone the US, and open a surgery practice. I have to do a retraining class. Do I want to do it at pace? No. Do I do a surgical re-entry course at other hospitals across the country that are available? That is the plan, should it come to that. The moment I am still practicing medicine elsewhere in the country, and I'd like to continue to be able to do that. Thank you.
Thank you, Doctor. Okay. Does the panel have any questions for counsel? And I'm not terribly familiar, so I'm going to leave it to Dr. Lewis. I'll start with you, sir.
Okay, I do have a question of Mr. Tan. Mr. Tan, you're aware that PACE has many aspects to it, correct?
Yes, Dr. Lewis.
And you are, as I hear correctly, recommending that all aspects of PACE be administered.
Yes, Your Honor. I'm sorry. Yes, Dr. Lewis. And it's because, first of all, and this was actually in a footnote in the decision by ALJ Larson, respondent has had issues with complications before as well. Over and above what Dr. Beneke found was a low, quote, low index of suspicion for potential injured patients. So that was in evidence. It's just that the ALJ found it to be irrelevant to the current case because, past issues with his medical care was irrelevant to the ultimate issue in this case, which was patient A in the laparoscopic cholecystectomy. But for purposes of determining penalty, Dr. Lewis, we believe that because of that conversation with Dr. Beneke and the fact that respondent was clueless about the CVS, we recommend full PACE, Dr. Lewis, to make sure that the public is protected.
Okay, now my other question is for Dr. Bloom. Dr. Bloom, who is your mentor? So many doctors have been thrown out there. It's a little confusing, but who is the mentor at the place of practice now? And if he or she was one of the commenters in this case?
Nobody I work with now was involved in this case or anything involving this case whatsoever.
Okay, so those doctors that your attorney and Mr. Tan had mentioned, none of them were involved in the case. As I understand it, they were just witnesses, expert testimony.
Dr. Beneke at the time of this event, Dr. Beneke was the chair of the department at the hospital at Sutter. He's the gentleman who gave me privileges to operate at that hospital less than a month beforehand. He was not involved in the case whatsoever until afterwards.
Okay, thank you.
The only people in the room at the time of the case were the patient, the anesthesiologist, myself, and 2 nurses.
Okay, thank you very much. I have no further questions. So we'll turn it over to
Dr. Yip.
Dr. Yip has a question. I'll go down the list.
Sorry, jump to this. Morning, Dr. Brom. During your surgical critical care year fellowship, did you do any surgery?
Yes, I did a few cases.
Did you do any cholecystectomy during that year?
Yes, I did.
Do you mind telling me how many?
I believe 3 or 4. I'd have to double check the record.
Thank you.
Dr. Lewis, you might be on mute.
Dr. Hawkins, you're next on the list. Do you have any questions?
Thank you very much. I had a question, I think it's been answered already, and that is whether this training in critical care was relevant to the issue before. So that is, were there laparoscopic cholecystectomies involved in that? And I think you said maybe 3 to 4 cases. Those are all laparoscopic cholecystectomy, and were they critically ill patients, since it's a critical care training?
During the year of my fellowship, I also did call at one of the program's sister hospitals. So some of those were on burn patients that I had during my burn month. Some of them were patients that came into the community hospital, sister hospital.
Okay, great. Thank you very much. And just 2 others. One is, and I don't know if I can ask this, you'll tell me if I can't ask this question. And really, I think it's probably on all our minds. With the passage of time, have you changed your approach to performing laparoscopic cholecystectomy using the CVS or some version of that, that if true could have affected the outcome of future cases? That is, are you incorporating that in your practice now to perform the procedures? This is clearly a critical issue, whether you disagree with the utility of it. Have you changed the practice, essentially, in performing laparoscopy?
Only part of what's described as the critical view, the 3-part view, the only part I disagreed with Mr. Tan being required for, and his expert, was the removal of the base of the gallbladder from the liver bed as being an absolute requirement that had to be done in every case. And as I had pointed, yes, sir.
I'm sorry, go ahead, please.
And as I had pointed out to Dr. Tan, Mr. Tan, that there are cases where there's absolutely no way to do that without completely releasing the gallbladder from the liver. And that in my training, up to that point, 20 other attendings I had operated with during residency and whatnot, I had never seen anybody intentionally remove that. Now, is that a way to get further space and to help clear the triangle, which is the end goal, and to have a very clear view of where the gallbladder leads into the duct and away from the bifurcation? I have no problem doing that, as I told Mr. Tan. Was it done in any of the cases where I did it solo or with other attendings during my fellowship? It did not. None of the attendings I scrubbed with there did it either.
So the last one is a follow-on to that, and don't let me put words in your mouth.
Okay.
The question I have is, do you feel that, part of which is the CBS, in my understanding, is that you isolate all those structures in this particular area that can be a closed space. Do you believe there's not a value in isolating all those structures, artery, veins, ducts, and all these things that may look a lot?
That's not the part I disagree with Mr. Tan. It's the 3rd part. The isolating the duct and the artery, absolutely. Those have to be clearly identified, and that's what I did. The 3rd part where we're having this disagreement is that the base of the gallbladder must be released, partially released from the liver bed before you clip and ligate the duct and the artery. That's it. There's no disagreement about cleaning and isolating the artery and the duct. Absolutely no disagreement there.
Now, you mentioned Mr. Tan. We probably should talk about the physician experts who comment on Mr. Tan's a lawyer.
So, sorry, but I apologize for that, but at the time it was Mr. Tan who was promulgating it. His expert witness, Dr. D, and I apologize, I cannot get his last name out properly, came and presented that he believed that the critical review of safety in that three-step process of isolating everything and releasing the gallbladder from the liver was the gold standard and the be-all and end-all of how to do a laparoscopic cholecystectomy. And he presented his one document. He presented as a peer-reviewed paper from the Journal of the American College of Surgeons. Turns out it was a poster abstract as an electronic publication written by somebody who had not at least graduated med school, if not graduated college yet, given the citation on the article. And they put that in their intro. Whereas Dr. Strasberg, who's the gentleman who described the critical view of safety in the first place, quite clearly says it's not the only method to do it within the standard of care. And I also believe that Dr. Ted mixed up standard of care and gold standard. Dr. Strasberg, in the article, as evidenced by the article we submitted, clearly states that it's not the only way to do this case.
Thank you.
Okay, let's move on. This is the only way I can do it since I can't see everybody. I'll just go down the list. Ms. Lubiano, do you have any further questions for either party?
No, my questions have been answered. Thank you.
Okay, thank you. Then we have Dr. Tirado. Do you have any questions?
Yes, I have a question for Dr. Bloom. So any of those laparoscopic cholecystectomies that you performed while you were on your fellowship, did you have an attending surgeon supervising them?
They were as an attending there, yes.
Okay. No further questions.
Okay, and we have Mr. T.J. Watkins wrapping this up. Mr. Watkins, do you have any further questions of either panelists?
Yes.
Doctors, lawyers, whatever.
Good morning, Dr. Bloom and everyone, the rest of the panel. My questions, I've got about 5 questions. So my first question is, prior to your conversation with Dr. Michael Benneker on November the 7th, 2016, did you know what the critical view of safety for the LC surgery was?
The way we used it was...
Did you know?
Yeah.
Yes.
The critical view of safety as we used it in residency was that view, not that third step of releasing the liver from the gallbladder. As I said, I had never seen any of my attendings who I had operated with in residency do that at all.
So the answer is yes.
I believe what I believe to be the critical view of safety. Yes.
Before. Okay. My second question is, during that conversation with Dr. Benneker, did you make the comment that you were adhering to the principles that your attending physician impressed upon you during your training with respect to cholecystectomy, which was to cut in one fell swoop? So if there was any injury, there would be a nice clean transaction to the repair. Did you make that statement?
Quite likely. I can't vouch for that word for word. As for the clean cut, the training, the way we were taught was that when it came time to do the transection, you've cleaned everything, you're convinced that you have the right anatomy, and you're ready to cut this duct. Cut it across. Don't take small little bites, because if you've ever cut anything under tension and you try to cut it, you never cut it cleanly. You end up with a ragged edge. And then if you have made a mistake and you have to fix this ragged edge, you have to clean the edges, which makes a tighter anastomosis and makes it more difficult. Therefore, if you're going to cut it and you're convinced that you have everything correct, cut it.
So the answer is yes again.
Yes.
Okay.
But
so
out of context, it sounds...
My next question is, you have a resistance to going to PACE. Is there a particular reason for that? when it is the most complete way for us to make an assessment of your competency in this particular deal and your overall role as a physician?
From my only exposure to PACE is what I've seen on the website. And I can get a better, and as I said, I've been out of surgery in standard practice for 2 years. The only way I'm ever going to get privileges to operate as a surgeon anywhere is if I do a surgical reentry course, which is a multi-month period of time working with surgeons in surgery. That would be a much more complete way of ensuring training. It gives me a guide, a book with which to present and say, this is my course, this is my active log. This is what I've been doing for the last 2 to 3 months.
Is that peer reviewed?
That is in the context of a hospital, under the premises of the surgery department of the hospital.
Okay, my next 2 questions. I'm going to step into the forbidden territory. You have licenses in Iowa, Washington, Illinois, Oklahoma, New York, California, and now in Michigan, 7.
Wait, let me just, New York, Florida, Michigan, Illinois, Iowa is inactive, Oklahoma, Washington, and California. There are 8 total, 7 are active.
So during your stay in 2015 in Washington, what was the reason for you departing from the facility in Washington, in your own words?
Mr. Watkins, I don't have the whole hearing transcript, but I want to remind you that this is the questions need to be on the records presented and not outside of the evidence that was already presented. So you have the opportunity to clarify, but not add. And I'm not correcting because I don't have the record. I'm just reminding you.
Everything I'm asking you is on the record, or everything from the first page to the last of the 10,100 pages. So my question.
Okay, understood. Go ahead.
So my question again is, in your own words, because we have the record, what was your reason and understanding of why you left Washington, the facility in Washington?
I left there. I went straight to another facility. They did not want my services anymore.
Okay, so that's your answer. Thank you. So in Oklahoma in 2013, a peer review committee of Mercy Hospital Ardmore.
What year?
2013. When you were in Oklahoma, were you in Oklahoma? This was in 9/27 on the 16th, a peer review committee at Mercy Hospital Ardmore.
In 2016?
Yes, in 2016.
Okay.
The peer review committee and conducted the case. And yeah, you have access to the record. You were placed on the National Practitioner Data Bank, and you made some statements about why that was wrong. They retracted it. Can you tell us what that?
They didn't retract it, sir. They rescinded it.
Rescinded it.
As in, it should never have existed. They completely fallaciously put it in.
So that committee's findings was not rescinded.
That committee's findings were made completely without my input.
Though, but it was based on medical records, right?
I would presume so. I don't know. I wasn't there at all. I had nothing to do with it. I didn't know that it happened until after I was told by Sutter about this.
Yes.
That's why I got suspended at Sutter. It had nothing to do with this case.
Okay. And then in 2014 in New York, where you also held a license, a medical malpractice insurance settlement was paid on your behalf, right? In that settlement complaint, it was alleged that you were clipping the common hepatic duct during a laparoscopic cholecystectomy in a 50-year-old female, resulting in obstruction. Is that accurate? Even though the medical or did not take any disciplinary action. Is that accurate? Because that's on the record.
That's the allegation. I don't know, and the surgeons who went back in did not identify what the cause of problem was. She came back to me 1 week after the case and then presented 3 months later entirely somewhere else.
It's
quite possible I did. I don't know. The case was settled without going to trial, not under my, the insurance company did it on their own. So I did not have a chance to look at the records.
Did you look back at the records of your Oklahoma's peer review committee finding?
I've looked at those cases, yes.
Okay. So my final...
some of them are quite comedic as to what I'm being accused of doing.
Comedic in what way?
One of the gentlemen was a 91-year-old cachectic gentleman who came in with a perforated gastric ulcer, which I treated appropriately. He was eventually sent to a nursing home about 2 weeks later after having a endoscopy done because he had an esophageal stricture also, which went in and looked at the repair and said it looked completely fine. When he returned after being sent from his nursing home to the local hospital, which is more of a clinic, a day later he was sent to the hospital in Ardmore. And the ultrasound showed, the CAT scan that he presented with showed some fluid around his stomach. I had a discussion with the family, I had a discussion with the patient. He unfortunately expired when he was put on the operating room table as I talked to the family. And apparently something was wrong with my original surgical technique because a gentleman with an albumin of about 2 dies. I found that a little unusual. The surgery was done properly. The repair was done properly. The patient was treated properly. That does happen, that everything is done properly. And the very anorexic, cachectic 91-year-olds still can't make it through. But that was one of the kinds of patients that they were accusing me of.
Okay, so we are in California right now. So my question was, did you settle another medical malpractice insurance case for this patient A in California?
No.
You have not settled. Okay.
Correct.
So my final question is, throughout this 10,000 pages, when you read through the actual court transcript, it becomes very apparent that you are convinced that you did nothing wrong, that you will only accept the very minimum of kind of disciplinary action, because you've had the experience of no action taken in Washington, no action taken in Oklahoma, no action taken in New York, right? For cases that was brought forth. My question, and this is my final question, is what can you tell us that would instill within us that you are not I want to get to this word because I've never used this word, irreparable attitude. That there is nothing that we can do to actually rehabilitate you or get you to perform in a particular direction with regard to getting more training, as in this case, safe pace.
Well, the state of Oklahoma looked at it and decided that there was nothing that required any action. There was nothing presented to Washington. There was no case issues in Washington.
So I have,
as I've said, the only way I could operate again is to do a retraining course. And so a much more practical one is a 2 to 3 month training period, not 3 days and some ungodly amount of money at pace.
But in California, a patient was harmed, and we never mentioned that.
This whole
Yeah,
thing is about
so
that patient.
this is what I'm hearing. I'm hearing you are telling us all that how you've been victimized in this case. You were your opening statement to us was that how difficult it was for you. I'm just going to give you the exact words. How difficult would it would be for you to go back to surgery, the 3 months that you have to do to get into introduction?
That's not a complaint. That's a statement of fact. This pace against this pace argument, which, as my understanding, is 3 to 5 days. I'm saying that the only way to get in is 2 to 3 months. I'm missing
the pace requirement of this board is to ensure public safety, right? When I was making reference to the irreparable personality, I'm trying to establish for myself whether that is true.
Okay.
And when you continue to say I did nothing wrong, which echoes through the whole transcript, and it echoes in this hearing as well, it echoes in the way that you say, well, it's not the CBS is not the only way, but it
is not. That's not me being irascible. That's a statement of fact, sir.
But the other statement of fact is that your experts did not prove that in a hearing.
The gentleman who described it.
They did not. Your experts did not prove that in a hearing. That's the fact.
But the evidence submitted says
Mr. Watkins, I think this discussion is devolving. Excuse me. Wait. I think this discussion is devolving.
Yes.
Mr. Watkins, if you have further questions, I will take them. But at this point, I think that for the most part, you have gotten from Dr. Bloom what you were seeking.
Yes, thank
Fair
you.
enough.
Let's
Okay.
move on. That's the panel members have all been queried about questions. I'm going to ask one more time. Any pertinent questions that haven't been discussed? If there are, please be very brief now, because we're behind schedule and we have a lot of oral arguments, and we want to give deference to the other presenters coming up. So, anybody else have a pressing comment?
Dr. Hawkins, please.
Dr. Hawkins, please.
Dr. Bloom, do you believe using the CVS as is presented would have changed the outcome in this case?
No, I don't think so. It's been 6.5 years by now. I don't remember exactly what the junction looked like between the liver and the gallbladder. It might well, it may not. I'm not sure.
Thank you.
If I had a picture in front of me, maybe I could come up with a better answer, but I'm not sure.
Okay. Judge, would you like to make any further comments, or are we ready to end this discussion?
That will conclude for today. I will ask everyone to pause for a moment when we conclude. The record is closed. The matter is submitted. We are off the record. Ms. Watford, there was a lot going on there. Do you need any of the expert names spelled or anything else?
I believe I have the documentation from the previous hearing, so I think I'm okay. Thank you so much.
Okay, great, thanks. Could I get an ended time and an estimated number of pages?
Yes, ending time is 10:25 and estimated number of pages is 54.
Okay, thank you. All right, we can, Dr. Bloom, thank you. You're free to go. Mr. Giardina, I believe you are remaining with us. And Dr. Lewis, does the board need a break before we move
Yes,
on
let's
to
take a
Dr.
5-minute break since it's about an hour and a half. If people need 10 minutes, fine, but we'll try to make it for, you know, an environmental break and then come back. Okay, we'll be back in 5 minutes. It's 10:26, so add 5 minutes to your watches. Thank you.
This is Sean with the medical board. Perhaps during this time, Judge Rowan, I can start calling up the participants for the next oral argument. You're okay with that?
Yeah, that'd be great. Thank you.
Okay. Okay, so let me go ahead. Update a few people here.
Sean,
Yes, Dr. Yep.
are we supposed to get out of this and then log in again for a closed session?
We are going to do all of the open session oral arguments and then switch to the other meeting to do the deliberation afterwards. So I'll give you when we get through all the oral arguments. But
So we'll do all four closed sessions after all the 4 oral argument, right?
correct.
Okay, got it. Thank you.
Okay, Dr. Droubay, are you there? Droubay, I'm sorry. You should be a panelist now and able to unmute your microphone and start video if you're interested. And let me also get Ryan Yates, are you there as well? You both would be on mute if you could unmute and let me know if you're there, or maybe you already snuck away for a quick break. But
Can you hear me, Sean?
yes, I can, Ryan. Thank you. Okay, great. You're in position. We're going to get started just after 9:30 here, but thank you for confirming you can speak.
Great. I'm glad I had 0 technical difficulties. I was worried about that.
Yeah, no, I don't know what is going on with the defense attorney, and at least we can have him speaking. But Lawrence, you're still there, right? You're still able to hear me and speak.
I'm Dr. Droubay. I'm unmuted. I am here. I had a little trouble getting off mute, but I am here. I'm going to mute myself back again, unless you want to hear from me.
No, thank you for confirming. If you do have video, you can start that too when we get going here as well. And since Lawrence was speaking early, I'm sure we're set on that end as well. So that would be the participants for oral argument 2 coming up here. And as Dr. Lewis said, we'll come back in just a couple of minutes. So thank you very much. Okay, Dr. Lewis, I was able to check in the respondent and the respondent's attorney and the DAG assigned for oral argument 2. So whenever you guys are ready to proceed, please feel free.
Sean, do we have everybody check back in with us?
It does look like all the panelists are back. Dr. Torado's video isn't up right now, but maybe you want to just roll call them or something real quick before we get going.
Yeah, let's check in with the panelists here, another roll call to see who's missing, if any.
Dr. Hawkins? Dr. Hawkins?
Here.
Ms. Lubiano?
Here.
Dr. Torado? Mr. Watkins?
Present.
Dr. Yip?
Present.
Dr. Lewis?
Present.
Dr. Torado?
Present.
If everybody's Judge Rowan back with us? Let's see, is she in? Hold on. Rowan. Is she here? Judge Rowan, are you there?
I'm back. Are you talking about me? Yes, thank you. Sorry about that.
Yes, you're here. Okay. Everybody's back. Okay. Next item of business is to hear the oral argument on the non-adopted proposed decision of Dr. Droubay. So I'll turn it over to
Thank you.
and we have a quorum.
Thank you. Mr. Giardina, you are representing Mr. Droubay, is that correct? Dr. Droubay.
Yeah. Yes, Lawrence Giardina for Dr. Droubay.
And Mr. Tan with the Attorney General.
Sorry, Your Honor, this is Ryan Yates, Deputy Attorney General,
Okay.
and I'll be representing the complainant.
Okay. Thank you, Mr. Yates. It's hard to see when it's hard to tell when I can't see everybody. Okay, so is Dr. Droubay with us today?
Yes, I am here. Thank you very much.
All right, thank you. Okay. Ms. Watford, when you're ready, we will go on the record.
I'm ready, Your Honor.
Thank you. We are on the record before the Medical Board of California in the matter of the accusation against Peter Edward Droubay, MD, Medical Board number 800-2016-04837, OAH number 2019-071061. This is the date, time, and place set for oral argument in the notice of hearing for oral argument. My name is Heather Rowan. Can we go off the record, please?
Okay.
Could I please ask if you're not speaking to mute the? It's hard for the court reporter if there's a lot of background noise. Sorry about that. Let's go back on the record.
Okay.
I'll just pick up. My name is Heather Rowan. I'm an administrative law judge with the Office of Administrative Hearings, and I've been assigned to preside over this hearing. Prior to going on the record today, we established that there is a quorum of Panel A of the Medical Board. May I take the appearance of counsel, starting with the Deputy Attorney General, please.
Good morning, everybody. This is Ryan Yates, Deputy Attorney General representing complainant, the Medical Board.
Thank you, Mr. Yates, and for Dr. Droubay.
Good morning. This is Lawrence Giardina on behalf of Dr. Droubay.
Thank you. The board has issued an order of non-adoption of a proposed decision by administrative law judge and has decided to determine the matter itself. The board has invited discussion of whether the proposed order should be modified. I'm sorry, the proposed penalty should be modified. The following time limits apply. I will give respondents counsel 15 minutes to make an opening argument, with a response by the Deputy Attorney General for 15 minutes, and then 5 minutes closing from each party. I will make every attempt to let you know when you have 1 minute remaining on your time. If Dr. Droubay would like to address the panel regarding the penalty, I will swear him in, take that under oath, and give the doctor 5 minutes. We will conclude today with oral arguments and any questions the panel may have for respondent. Following the close of today's discussion and the panel's closed session deliberations, a written decision will issue sometime in the future. Is there anything we need to discuss, Mr. Yates, before we begin?
Nothing here, Your Honor.
Mr. Giardina?
No, Your Honor.
Okay, thank you. I'm going to start your 15 minutes. Mr. Giardina, when you're ready, go ahead.
Thank you, Your Honor, and good morning again to the members of Panel A, to the Administrative Law Judge, and to Dr. Droubay. As I believe the panel can see, there is an agreement between the medical board and Dr. Droubay in regards to how to proceed. If one looks at the complainant's brief, we will see that they agree with Dr. Droubay's position, which is in an unrelated matter, which has nothing to do with this case. Dr. Droubay has agreed to surrender his license, and indeed has already surrendered his license and has complied fully with that decision. We, and I believe Mr. Yates would agree, believe that this matter is moot and that Panel A, in an abundance of judicial economy, should simply adopt the administrative law judge's decision as written and move forward. The purpose of Panel A's review of the decision of the administrative law judge is to make sure that public safety is protected. There is nothing about the surrender by Dr. Droubay that would in any way endanger public safety. Dr. Droubay has advised that given his age, he has fully retired and has no intention of any sort to engage in the practice of medicine. That motivated our decision in an attempt to not only for financial reasons, but to end his career by surrendering his license on other issues, which we may completely dispute those, but the fact is that Dr. Droubay made the decision that he was retired and that there was no reason to continue a expensive and ongoing fight. So Dr. Droubay has surrendered his license. And in this case, I believe that there is, Mr. Yates and I have spoken, and I believe that we both agree that if the board simply accepts the administrative law judge's decision in this matter, then we can put the matter to rest satisfactorily on both sides. That is my recommendation. I'll let Mr. Yates speak for himself, but we believe that is the best course. If the board wishes to address the merits or address some desire to evaluate the efficacy of increasing the penalty, I would be happy to address that. But I believe that given the position of the Deputy Attorney General and myself, that's unnecessary. I'll reserve that time in the event that the board wishes to address those issues. And with that, I will submit the matter to the board, Your Honor.
Thank you. I will make a note, Mr. Giardina, you have 11 minutes remaining. Mr. Yates.
Thank you, Your Honor. Yes, Mr. Giardina is generally correct. This is probably a rare situation where the parties aren't really disputing too much at this point. Regarding Judge Brown's findings, my office agrees fully with the findings. The analysis was solid. The credibility determination was completely there. And we completely agree with her conclusions. The one thing that my office might not necessarily agree with was the penalty, which was a substantial probation. However, we had initially asked for a revocation. Now, We don't believe that that by modifying the penalty to a revocation, the public will be under any sort of increased protection, because in this separate, unrelated issue, we do have a surrender. So if the board chooses to adopt the proposed penalty by Judge Brown, the surrender will take effect and Dr. Droubay's license will be no more. However, we don't necessarily oppose increasing the penalty to a revocation, but we would heavily oppose any sort of a decrease in penalty. So with that, I submit as well.
Okay, so this is a bit of a different situation. I think that what I should do is see if there are any questions for the board, and before I move to the remaining time. So Mr. Lewis, would you like to pick up? We can poll the board and see if there are questions about about why the decision was non-adopted while the attorneys are here and can answer those questions. Mr. Lewis? I'm sorry,
Yes.
Dr. Lewis, my mistake.
Oh, that's all right. I'm going to go ahead and go down the list for any substantial comments or questions, seeing how both parties are in basic agreement with the outcome of this case. So, Dr. Yip, any pressing comments?
No, thank you.
Okay. Dr. Hawkins, any comments?
Yes, just briefly, at least one person felt that the discipline should be license revocation. My question is, and I quote, if, quote, some issue related to license surrender, that I think that the attorney Giardina said that some issue related to license surrender might be litigated in the future, if I understood him correctly. How can the panel be confident that the public will be protected if, in fact, this is litigated and this physician gets his license reinstated?
Thank you for that question. It's Lawrence Giardina. That comment was directed before Mr. Yates and I had the decision. Obviously, I submitted my brief first, and so that Mr. Yates, knowing now that he has agreed to not further the penalty in this case, that Dr. Droubay stands ready to accept that, and we are not going to appeal it. However, until we had that agreement, I wanted to keep options open for Dr. Droubay's purposes.
Thank you.
Hey, Ms. Lubiano, any pressing comments or questions? Okay, moving on.
Miss Lubiano is speaking. Were you on mute?
I can't. Is she?
I saw her speaking and I can't hear her.
Well, we can come back to her if she gets back on.
Ms. Lubiano, I see you speaking. I can't hear you. So there's just some issue going on, and we'll come back to you.
We'll come back
Dr.
to you.
Lewis? Okay.
Yes, Dr. Tirado, any comments?
No, thank you.
Mr. Watkins, any comments?
Yes. For me, the severity of this case, why we non-adopted this case, and the severity of the case that involves 3 different patients, a pattern of behavior, I feel strongly that we need to revoke this license and let the process proceed.
Okay, thank you for your comment. Ms. Lubiano, are you back online?
Can you hear me now?
Yeah, I think you go on mute a lot, or somebody puts you on mute without your knowledge.
Okay. Glad you can
Go
hear
ahead.
me now.
Yes, go.
Just
Yes.
a clarifying question. procedural question. So with the surrender, what does that look like in terms of, can the doctor seek reinstatement at any time later?
Yes, you can seek reinstatement after 3 years.
Which would be, Mr. Yates, that would be a petition to the board. So the board would have that determination. It's not like reapplying for a license. Is that correct?
That's correct.
Okay, thank you.
Thank you.
Okay.
No further questions.
And I have no further questions. So I'll turn it back over to the judge.
Okay, so can we go off the record momentarily?
Okay, off the record.
Dr. Lewis, I have not had this situation before where there is basically a stipulation. The board has asked the questions that it has, and you can deliberate. Did you want to consult with your counsel, with the board's counsel before continuing, or do you just want to end this portion of the hearing right here? And that is that's.
Well,
I want to put that question to you because it's not mine.
Yes, I would prefer just to close it now, and when we do our closed arguments, closed deliberations, we can just quickly take it up then, unless our counsel, Ms. Webb, has another brilliant suggestion, which she always comes up with. So can we ask her that question?
Ms.
We're
Webb,
off
are
the
you
record.
on the line? We are off the record. This is not part of the actual hearing proceeding. I just want to get the procedure that you are comfortable with.
Ms. Webb, are you there? Oh.
If you're speaking, you might be muted.
Carrie's having some issues here real quick.
Okay.
Can I interject here for a minute, since we're off the record?
Carrie's asking you guys to hold on just a second.
Carrie, are you on?
Can you hear me?
Go ahead.
Okay. Sorry, it was connected to video. If you should not discuss votes, you should not discuss, you should not deliberate this case until the panel is in closed session. And so if you are done asking questions, then the panel should continue to the next oral argument.
Correct. Okay, that's what I thought. Okay. Judge Rowan, do you want to go and continue?
Yeah, we'll go back on the record to conclude. We are back on the record. We went off the record briefly for a procedural issue. Because the parties have answered the panel's questions, but each has several minutes remaining, I want to confirm with counsel that you have no rebuttal. Mr. Giardina?
No, Your Honor.
Mr. Yates?
Yeah, I would just like to briefly just state, we didn't make any sort of outside agreement regarding this portion of the case. It's really just my office's position that the public, based on these unique facts, is adequately protected. However, we don't oppose any sort of modification to a revocation. And with that, I submit.
Thank you, Mr. Yates. Okay, the record is closed. The matter is submitted. We are off the record. Ms. Hartford, anything that you need spelling-wise?
No, I think I'm okay, thank you.
Could I get an ending time and an estimated number of pages, please?
Yes, ending time is 10:52, and estimated pages is 15.
Thank you very much.
I don't get any input. Is that the idea?
My understanding, and Mr. Giardina, you can correct me on this, I understood that you had addressed the penalty, which is what Mr. Droubay would have been addressing. Did you discuss
Correct.
that with your client?
We'll submit, Your Honor.
Okay, thank you. Dr. Lewis, I will leave it to you, and Sean, if you want to proceed to the next hearing.
Yes, give me just a moment to bring up the other participants here. Thank you.
Okay, we'll wait. Everybody's on mute.
Okay, I have Monica Harms. Monica, are you there? If you could come off mute and let us know. And Joseph McKinley, you as well? You're both on mute. If you could come off mute and just, you should be able to start your video now if you have that option, and let us know if you can communicate.
Present. Monica
Thank,
Harms.
thank you, Monica. And Joseph, are you there? I know we're about on time, so. There we go, Joseph. I see you come off mute. Okay,
yeah,
great.
I did come off mute. I'm looking for the video option, however.
In the panelist list where you see your name next to you, there should be a little camera button there if your workstation is
not.
equipped with a camera.
It is, however.
You could go to the little audio and video menu up at the top, and there's a camera option in there generally, and you should be able to select the camera if you have one equipped.
It says connecting, so fingers crossed.
Yeah, I'm not seeing.
Is my audio fine?
The audio's working fine, yeah, but I'm not seeing the video
Okay.
come up. Yeah.
I'm sorry for the delay. It says looking for nearby device. No devices found. I don't know why. There is a camera on this laptop. I have used it for prior appearances and Zoom meetings, but I can say I haven't used it with the WebEx platform, and I don't know if that's an issue, but it is an actively working camera. I'm sorry.
Ms. McKenna, did you download the in WebEx Connect? At the bottom, you have to load the program and
No, sir. I know I didn't
download
do
it.
that. I did not download anything with this. I apologize.
Even the plugins should work, but they're most likely some sort of configuration issue. I would say in the interest of time, if everyone's okay, to go ahead without the video.
I'm okay proceeding with audio, but I'll await the direction of the court and the panel.
I'm fine with audio. We can hear you just fine. If the panel does not have an issue, we will proceed. Mr. McKenna, if there's some point at which we cannot hear or understand you, I'll make sure to stop you right away. Panel members, if this is not how you want to proceed, please raise your hand. Otherwise, we will continue. All right, no objections.
Once we can hear him, we're fine.
Agreed. And Ms. Harms, I heard you were on the line. I just want to confirm that we can all hear you.
Yes, Your Honor, and I'm having the same video issues as well.
Okay. Given that we can hear you clearly, I think that we can proceed with the hearing. I want to remind everyone that if you are not actively participating, that you mute your microphone, and in the interest of eliminating background noise. Okay. Ms. Watford, are you ready to go on the record?
Ready, Your Honor.
All right, and I realized, I think the last time I said your name, I said it wrong, and I apologize for that.
No problem.
Okay, we're on the record before the Medical Board of California in the matter of the accusation against Monica Harms, MD, board number 800-55928, OAH number 2020060594. This is the date, time, and place set for hearing and the notice of the hearing for oral argument. My name is Heather Rowan. I'm an administrative law judge. I've been assigned to preside over this hearing. Prior to going on the record today, we established there is a quorum of Panel A of the Medical Board. May I take the appearance of the Deputy Attorney General, please?
Good morning, Your Honor. Good morning, panel. Liz, my name is Joe McKenna.
Thank you.
Spelling McKenna is M-C-K-E-N-N-A.
Thank you. And Dr. Harms, you are on the line and representing yourself today, is that correct?
Yes, that is correct.
Okay. The board has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has invited discussion of whether the proposed penalty should be modified. The following processes and time limitations will apply. Dr. Harms will have 15 minutes to make an opening argument. I will let you know when you have 1 minute remaining. Deputy Attorney General will have 15 minutes to respond. I will then give each of the parties 5 minutes for a closing argument. Dr. Harms, because you're representing yourself, before you give your opening statement, I'm going to swear you in, take your testimony under oath so that you can address the panel regarding the penalty during your statement. The arguments are based on the existing record and will not exceed the scope of the record of the admitted evidence. No new evidence will be heard today. I will give the panel an opportunity to ask questions following the close of argument. At the end of the arguments, the panel will deliberate in closed session and a written decision will issue at some point in the future. Dr. Harms, before we begin, do you have any questions about this process?
No, Your Honor.
Okay, thank you. Will you, I realize I cannot see you, will you please raise your right hand?
It is raised.
Thank you. Do you solemnly swear or affirm under penalty of perjury that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Dr. Harms, I will give you 15 minutes to address the panel. I will give you a 1 minute warning, and you can start whenever you're ready.
Thank you, Your Honor. My intention today was not to submit a formal statement. I appreciate the opportunity I've had to learn from my mistakes, correct my judgment, and continue the practice. My main motivation is to be present to the best of my ability to answer any questions the panel may have in order for them to make the appropriate decision.
Thank you, Dr. Harms. And Mr. McKenna, would you like to give a statement for the, on behalf of the complainant?
Yes, thank you, Your Honor. This is very brief because as the panelists have before them, they have the Attorney General's written argument. And as made clear in the proposed decision I submitted at hearing, it was my opinion that based on the evidence offered at hearing, including the Dr. Harms' performance even before being placed on probation, since being on criminal probation for close to well more than 6 years of biological fluid testing, that she had satisfied her burden. However, we don't endorse petitions, but certainly I felt that she came into court with the evidence necessary and I did not disagree with the result. I felt it was a just result to terminate her probation just shy of 4 years of a 5-year total probation term. I believe now, as of today, is probably around 8 months, but however, I still felt the same last summer. Certainly I can answer any questions in particular, but I think my brief laid it out that I believe she came in as petitioner and satisfied her burden and presented clear and convincing evidence that she was entitled to an early termination, that she has done everything that the board would expect of a probationer, and certainly terminating early would not cause any, it would not compromise the safety. It's not contrary to the safety of patients or the public in California. With that, I have nothing further, Judge.
Thank you, Mr. McKenna. I apologize. I referred to this as an accusation at the beginning. It was a petition for reinstatement. That was my mistake. So given that the petitioner has stated that she's open for questions rather than give time for a rebuttal, I think that we can take this time and see if there are any questions from the panel. I'm happy to, now that I have the list in front of me, I'm happy to go through the panel, Dr. Lewis, or you can take control, but either way, I will turn it over to you.
Yes, and I would like for you, Judge, to again remind us if we go off track or out of record to bring us back in. So if you could do that, that would be helpful. So I'm going to go down the list, and we have first Dr. Yip.
Good morning, Doctor. As a current now, what is your practice, and are you practicing full-time, 40 hours a week? What type of practice are you now?
I am in a small group practice, and I am practicing full-time, averaging 40 to 50 hours per week.
And so far you handle well, no stress issue, right?
Correct. I think I've been able to manage my stress appropriately.
Okay, great. Thank you.
Okay, then we go to Dr. Hawkins. Do you have any questions of Dr. Harms?
Thank you for coming before us, Dr. Harms, and I have no questions.
Questions from Dr. Hawkins. Ms. Lubiano, do you have any questions of Dr. Harms? And make sure none at this time. Thank you very much. We go to Dr.
No questions. Thank you.
Okay, thank you. We have Mr. Watkins. Do you have any questions of Dr. Harms?
I've just got 3 questions. Good morning, Dr. Harms. You've been diagnosed with an alcohol use disorder of the severe form. What is your understanding medically of what that means?
My understanding is that I used poor judgment and that it is not alcoholism per se, but it is a concern relating to alcohol intake.
My second question, right now, are you applying, do you have knowledge of any evidence-based therapies that will keep you from relapsing?
Well, one thing I would like to point out is when I underwent the psychiatric evaluation, it was determined that there was no addiction. I would also like to point out it was determined that there was no underlying anxiety or depression that was found. So with regards to relapsing, my primary deterrent, which I think is extraordinarily significant, is I desire to continue the practice of medicine for many years, if not decades. And I am well aware that any transgression further on would absolutely cause me to lose my license, and I cannot risk that. I'm not willing to undertake activities that would lead that to happen.
In the record, there was a statement made by you that between your first DUI in 2009, where your blood alcohol level was 0.24 to 0.27, and your April 30th, 2014 conviction, where your blood alcohol level was 0.17, that you did not understand how that could have happened. And I'm paraphrasing. Right now, I'm interested in understanding if you have an understanding of the triggers related to the alcohol use disorder.
The trigger for the second event was a phenomenal stressful event, which actually occurred that evening. I have better measures in place to handle anxiety and stress for individual situations as they arise. I have made the decision following termination of probation or natural completion of probation. I cannot drink. I choose not to drink. And I am very comfortable with that decision going forward.
So right now, you're not using any evidence-based therapies to help you on your path.
What I'm using at the moment is I am going to group therapy, and that has been very beneficial early on. I question whether there's providing any benefit at this moment. I also am incorporating more secondary measures. COVID has, as we're all aware, put certain barriers into place. But at this moment, I feel I am in a good place in my life. I have no cravings or temptations to drink. And the group therapy I'm currently attending is what you would say evidence-based. That's what I have been doing at the moment.
And that's the only thing you've been doing.
As of today, at this moment, that is correct.
Thank you.
Okay, thank you, Mr. Watkins. And myself, I have no further questions, so I'll turn this case back over to Judge Rowan.
Thank you. Because the parties have several minutes remaining, I want to allow for any statement or rebuttal before we close today. I will start with Dr. Harms. Do you have anything that you wanted to add? Well, you have several minutes remaining, but I'm going to set a 5-minute timer.
Thank you, Your Honor. The main thing I think I've learned through the situation is what resources I have to utilize should in the future any particular situations bring about situational anxiety or depression. I have an understanding of what I can and should do, much, much more so than I had several years ago when the unfortunate events of my poor judgment transpired.
Thank you, Dr. Harms. Mr. McKenna, anything, would you like to add anything?
Other than, Your Honor, again, the Attorney General respectfully submits it would not be contrary to the public health, safety, and welfare to terminate Dr. Harms' probation at this point, approximately 8 months early. And I will also submit on my written brief. And that's all. Thank you, Judge.
Thank you, Mr. McKenna. Okay. At this time, the record is closed. The matter is submitted. We are off the record. Ms. Watford, if I could get the ending time and estimated number of pages, please.
Yes, ending time is 11:11 and estimated pages is 17.
Thank you. Okay, Dr. Harms, you're free to go. Does the board need a break, or would you like to move into I believe, the final petition, the final matter?
Well, it'd be nice to move into the final matter, but we also have to contact the Attorney General and the respondent. So, Sean, do you know if they're in the queue waiting for us, or
Supervisor Supervising Dag Terry Jones is here with us, I see, but I don't see anyone from the respondents list. Yeah, I'm scrolling through it here just to double check, but at this time I don't. I mean, if we want to take a short recess, I could reach out to them, but we did tell them 12:30 on temporary, the agenda that went out to them said 12:30.
Yeah, I know we should respect those times, but you never know if they're hanging. So we could contact, but otherwise the agenda has been set. So
Do you want me to, we want to take a 5-minute and I'll see if I can get a hold of them real quick? And
okay, we'll take 5 minutes and then we'll come back and get a check-in from you.
Okay, thank you. Be right back.
Any luck, Sean?
Hi, Dr. Lewis. I just got off the phone with Miss Green, and she's currently en route to her client, and they will be together for the oral argument this afternoon, but they were planning on the 12:30 time, and so I said we could accommodate the 12:30 time for them.
Okay, we tried, so. Okay, so is the rest of the panel back online? I need just to let them all know to come back at 12:25. Oh, yeah, with the, just leave this link up. Just
Yeah, literally, everyone could just turn their audio and video off and take a lunch break, and we can, reconvene at 12:30.
Okay, so how can we let them all know? Do they?
Ron,
Yes?
are we going to do closed session now or wait until the fourth case?
No, we can't start the last case because they're expecting 12:30.
But then I'm saying, are we going to do the closed session for the last 3 case or wait until the fourth case?
Well, we could do some of the closed session.
All right, it's Carrie. We are going to do closed session after all of the oral arguments are heard. We have a new security process.
Oh, that's right. We have to go out of this
Right.
WebEx and back in on a new link.
Okay.
So we are going to be closing down for lunch, and the next oral argument is scheduled for 12:30.
Okay, so everybody has to close the screen and then go back to WebEx and open up the closed link, correct?
No,
No.
We'll just go ahead and have you mute and stop your video for now in this meeting, leave it active, and we will pick back up at 12:30 right here.
Okay, because there was a closed link. Okay, then everybody just leaves their screen like this and goes away. Okay, see you at 12:25.
Sounds great.
Okay, bye.
Okay, thank you, everyone. It's about 12:30 p.m. I think we're about ready to get started here. I'm going to go ahead and take down this presentation, return to the normal mode. Andrea, go ahead and do a roll call for us, and we'll turn it back over to Dr. Lewis. I do see a couple empty desks right now, but let's see how this goes.
Okay, let's do a roll call to make sure we have a quorum. So could somebody please call the roll?
Dr. Hawkins?
Anybody see Dr. Hawkins? Are you muted?
Ms. Lubiano?
Yeah. Lori, unmute. Unmute.
Can you hear me okay?
Yes.
Yeah, hi. Okay, great.
Dr. Tirado?
Present.
Mr. Watkins?
Present.
Dr. Yip,
Present.
Dr. Lewis,
Present.
Dr. Hawkins.
Here.
Okay, we have a quorum.
Okay, thank you. We go back into open session with an oral argument on non-adopted proposed decision for Brooke Barton, MD. So if I could turn over the rest of the case to the ALJ, Judge Rowan, you're on.
Dr. Lewis, this is Sean again. I'm still not seeing the respondent's attorney. I'm going to give her a call one more time.
Okay. Yeah, that's fine. We have a quorum, so we'll just wait. Do you see Dr. Barton online? I don't see. Let's see.
Is good afternoon. Is Ms. Sanders from the Attorney General's office on the line?
Good afternoon, Your Honor. This is Terry Jones. I'm going to be making the appearance today on behalf of complainant.
Okay, thank you. Sorry about that. So we will give it a minute for, I think it's Ms. Green who's representing Dr.
After we finish the oral argument, we close the record. We're going to be going into closed session. And I think, Sean, don't we have to go out of this and back in a new web connect?
Dr. Lewis?
Yes.
Sean is working with the respondent's attorney right now. And so, but you are correct. Once the oral argument is completed, then this link will end and we will go into a confidential link for closed session.
Okay, that's what I thought. And we'll have to go back into a new web connect, which is in your email.
Right, Sean will explain it.
Okay, we have Ms. Green on the line now. Ms. Green, are you available? Can you unmute yourself down at the bottom?
I'd be happy to unmute myself. Yes, I should be unmuted. Can you hear me?
Perfect.
All right.
Yes. Okay, Judge Rowan, I'll turn it back over to you. Thank you very much.
Thank you. Ms. Green, is Dr. Barton with you?
Yes, she is.
Okay, great. Thank you. So we have the Deputy Attorney General Jones as well as appearance for respondent. So Ms. Watford, let's go on the record, please.
Who is she? Okay. Who's speaking?
Wait, before you go on the record, I'm sorry. I want to remind folks that if you're not actively participating, please mute your the app or the phone, whatever you're using, to cut down on background noise.
And Judge Rowan, if I could just make one more comment. Ms. Green, if now that you're joined in under the participants list, you should see your own name there. There should be a camera button if you are looking to start your video. If you have a webcam on there.
I do. I do.
There, it's come through. All right, perfect.
Yeah.
Thank you so much.
Sure.
Okay. Now let's go on the record. We are on the record before the Medical Board of California and the matter of the accusation against Brooke Millon Barton, MD, Medical Board number 800-2015-018519, OAH number 2019-041274. This is the date, time, and place set for argument in the notice of hearing for oral argument. My name is Heather Rowan. I'm an administrative law judge with the Office of Administrative Hearings. I've been assigned to preside over this matter. Prior to going on the record this morning, we established there is a quorum of Panel A of the Medical Board. May I take the appearance of counsel, starting with the Deputy Attorney General.
Good afternoon, Your Honor and panel members. E.A. Jones III, Supervising Deputy Attorney General on behalf of complainant.
Thank you, Mr. Jones. And on behalf of Dr. Barton.
Yeah, Tracy Green of Green & Associates for Dr. Barton, who's present. She's just simply off camera at this point, but she can hear the proceedings.
Okay, great. Thank you. If the board has questions or if she gives a statement, she may need to get closer to a microphone, but as long as she can hear, we'll move forward with the proceedings now. The board has issued an order of non-adoption of a proposed decision by an administrative law judge and has decided to determine the matter itself. The board has invited discussion of whether the proposed order should be modified. The following time limits will apply. Respondent will have 15 minutes to make an opening argument. Deputy Attorney General will have 15 minutes, and then I will give 5 minutes for a rebuttal on each side. I will attempt to interrupt you when you have about a minute to go to let you know to move into closing. Following argument, if Dr. Barton would like to make a statement regarding the penalty, I will swear Dr. Barton in and take that statement. That statement should be 5 minutes or less. The board may have questions for Dr. Barton, and we will address that following that statement. Is there anything we need to address before we move into argument?
Not that I can think of, Your Honor.
No, Your Honor.
All right, thank you. Ms. Green, you have 15 minutes, starting now.
This is a case where we have a psychiatrist who handled 4 complex cases and where the court, the administrative law judge, heard 8 days of testimony. And Dr. Barton herself was on the stand for several days. I know that the board could look at this decision that was issued by the administrative law judge and think, well, what's the basis of this? Why would he recommend 3 years probation? And when you look at the transcript and the testimony of Dr. Barton and the exhibits, you'll see that Dr. Barton is extremely well trained and that she had excellent medical reasoning and justification for prescribing as she did. One of the, I think one of the concerns was, well, what happened with Dr. Barton? Why weren't these records produced right away? Is she just dismissive of the board and not willing to follow their rules? No, completely to the contrary. This case was started by a complaint regarding one patient, which would be patient D in the accusation. And then the board went and looked through the cures reports and chose 3 other patients, patients A, B, and C. Now, A, B, and C specifically wrote to Dr. Barton and specifically wrote to Dr. Barton in writing and one with their attorney and demanded that the records not be produced to the board. And this was several years ago when the law was still unsettled as to whether or not, with respect to a psychiatrist, do these records need to be produced in full? And it wasn't simply the records of, let's say, the prescribing or just basic notes. Dr. Barton sees patients for a 1-hour period and also does psychotherapy. So there was extensive testimony by Dr. Barton about patients A, B, C, and D. And the fact that, for example, with patient A, that she was running a company, she had come to Dr. Barton having been on certain medication for 10 years, that she worked with patient A's internist, and she had valid reasons, and that are also supported by when you look at the exhibits that were produced by complainant, in terms of what the standard of care is and what the decision making was on that case. The same thing with patient B. Now, patient B, he was a top salesman for an entertainment related business, had long-standing sleep apnea, long-standing other psychiatric issues. He had been on Ambien, he'd been on other things for years. When Dr. Barton started treating him, she worked with his physician, she worked with him. And similarly with patient C. Patient C was a city attorney for the city of Los Angeles, was someone who had had years of issues before she met Dr. Barton, complicated case, and Dr. Barton worked with her over the years and ultimately really ended up having quite a successful result. And that testimony is just replete throughout the case. And this isn't a case where doctor, was just simply prescribing, someone wants Xanax or a benzodiazepine. Not the case at all. And Dr. Barton, essentially had to address in her testimony things like, well, why with a certain patient, for example, patient B, why would there be, let's say if the patient were taking one sleep medication, why would there also be a small dose of a benzodiazepine such as Xanax? Why would that be given? And the board's expert had said that just simply was below the standard of care. And Dr. Barton really showed through literature and, in addition, explanation in terms of some anxiety issues that patient had, that falling asleep, that small dose will help fall asleep, and where then, let's say, the sleep medication would help the patient stay asleep. This was something, the board's expert had made a statement such as, a patient who has sleep apnea should never be taking Ambien. These were things that documentation was shown, testimony was given by Dr. Barton to show that the board's expert, who's a psychiatrist who practices at Kaiser and is in a managed care program, that some of the guidelines that he was proposing really are not reflective of the standard of care. The board's expert's opinion was that the goal is not to help a patient become functioning. The board's expert had contended that if a patient came to Dr. Barton, let's say like patient A or B, and had been on certain medications, that the first day that Dr. Barton sees that patient, or patient D, for example, with Xanax, that she should have had a plan immediately written on how to taper that patient off. This wasn't a prescribing case where people came in and asked her for things. These were complicated cases, and the detailed notes, each patient note, handwritten notes for probably 10 or 12 pages, handwritten for each patient visit. So there was some prior discipline that the doctor had before. That was many years ago. She had no other lawsuits, did not have any other complications. There was Dr. Ross, who trained at UCLA, very well respected. He testified on her behalf and proclaimed that she's just one of the best in psychopharmacology. Dr. Barton takes the tough cases and people who have some mental health diagnoses, but yet want to be at full functioning jobs. Patient D was the one who got the attention of the board, and he, as was set forth in the testimony, was a producer for one of these survival type shows and was going out of the country into far-flung places with no pharmacies. So that was an instance where she had prescribed an amount to last him, because if she did not, well, then he could, if he abruptly discontinued, then we know seizures could happen. So his was a case where she did have a plan. He ended up with a little bit more medication than he should have had, but it was simply because of the unique circumstances of his case. And she really put a good plan. Also, he had already been on Xanax for 5 years. And the testimony by Dr. Barton was insightful. It was incredibly detailed, and it showed this knowledge of the body of psychopharmacology that was far beyond what the board's expert had put on. The board's expert would make a statement such as a patient should never receive more than 4 milligrams of Xanax, for example. Well, all that needed to be attached was the PDR, the physician's desk reference, which was attached, and one would see that's just not the case. So when you look at it, and the cross-examination of the board's expert that was done was also quite thorough and was to show sort of the limitations. The board's own expert initially had a report where he thought that patient B was an 88-year-old man. Some of these, and he had other misstatements. He would mix up, dexedrine, he would mix one medication for another. One of the board's criticisms was that patient A was receiving phentermine, and was receiving a stimulant. And his criticism was, the patient wasn't being weighed. The patient's weight wasn't being monitored. Dr. Barton, showed that there was studies, and which are attached as exhibits, that describe how in cases where someone has had depression and patient A had ECT and had treatment for over 20 years, that little bit of a stimulant in a phentermine, or even sometimes like in a dexedrine, that can help activate that individual in addition to their antidepressants. So it wasn't a case of her being careless or negligent or not knowing what she was doing. In fact, it was the contrary. It's someone, a psychiatrist who really cares, who tries to get her patients fully functional. And, it was just sort of a bad start, I think, initially that happened, where the case went to the Superior Court, and until a decision, there was a decision that came down that said the records did need to be produced. The Superior Court had jurisdiction to order fines against Dr. Barton. They did not. There was, when the records had not been produced fully by my office, right after court, then the court issued, I had an illness and had to be hospitalized for a day. The court issued an order, which was a warrant, but immediately quashed it. The records were produced. Everything was done properly in that regard. A 3-year probation may seem like it's a slap on the wrist, but for Dr. Barton, we all know it's a very serious consequence. She took prescribing classes. She went ahead and took record-keeping class. She did all of these things, before the hearing, and some of them after the hearing, and provided proof. She does not want any of the board members to ever have to be concerned about her or her treatment of a patient. And in fact, she made some changes to some of the paperwork and some of the documentation, and she provided evidence of that at the hearing. So Dr. Barton really, did her best to earn the right to show the administrative law judge and the board that she cares about patients, that she's very responsible and methodical, and in fact, that she took any of these criticisms about record keeping to heart. I mean, for her, she can read them, and she believes that most other individuals should be able to read them. She's not in a managed care system. She's a solo psychiatrist. But cases like this are why some psychiatrists will write down practically no psychiatric notes or psychotherapy notes because they're afraid of them being discovered. In this case, these patients, voluminous records were attached. So Dr. Barton, would ask the board to please go along with the administrative law judge's very meticulous decision where he had a chance to observe her for 8 days. And a number of those days, most of the days of hearing were all in person. So he was there from the beginning to the end and saw her. If the board feels that a certain additional requirements are to be met, would ask that they be in the form of continuing education. This certainly was not a case where her competency in terms of her medical decision-making or her ability or knowledge of psychiatry was in question. And you'll see if the court, if the board members, anyone reviews the testimony of Dr. Barton and the cross-examination, you will see that she was very thought out. I really, I think she did a very good job at explaining, what she does with complicated patients. The board guidelines here, are not, do not call for revocation here. Believe that would be an abuse of discretion under this particular record. I mean, the testimony is so extensive. This isn't a case where me and Joel Douglas went in and somehow persuaded an administrative law judge who's very experienced to give a light tap on the wrist. This isn't a, something like a public reprimand or a citation. This is 3 years of probation with someone who's had a long career. She has great credentials. She's, came to UCLA back in the 80s because of its expertise in psychopharmacology. She studied with some of the best attendings, and she has kept up her practice. She maintains, even though she's on her own, she's completely the person who stays up on journals, stays up on the new medications. It actually was really impressive because there are a lot of psychiatrists who don't go above and beyond to try to get their patients fully functional. The board's expert didn't think that a psychiatrist should do that. This psychiatrist has a different approach, and it doesn't mean the board psychiatrist is wrong, but in terms of the standard of care in California and in Los Angeles, Dr. Barton was within it. I would
Ms.
hate
Green?
to, yes.
You have about 30 seconds, so go ahead and close it up.
And I would hate to see Dr. Barton punished unfairly, because the records will show that she produced the records, she had counsel through the production, and any delay was based on advice of counsel or counsel. It was not due to her own doing, and that's very documented in the record. So I think this is a case where it's nice to see that the board is, taking a second look at cases. But I believe that when they take a look at this voluminous record, they will see that the administrative law judge got it right, understood the issues, and gave a very reasoned, evidentiary-based analysis.
Thank you, Ms. Green. Mr. Jones, when you're ready.
Thank you, Your Honor. The ALJ correctly found unprofessional conduct, gross negligence, repeated negligent acts, record-keeping violations in this case. He recommended, as you're aware, 3 years probation with coursework and a practice monitor to remedy these violations and to protect the public. We would submit that probation is insufficient to protect the public and that revocation is required. I would point out that the board's guidelines do permit revocation as a remedy for gross negligence, contrary to counsel's suggestion. Now, a review of the circumstances of 1, the violations involved, 2, the course of the investigation, and 3, the statements of respondent in support of her defense support this conclusion. Regarding the violations, complainant's expert, Dr. Hartman, was the only expert to testify regarding the standard of care as applied to respondents' treatment of 4 patients. I would note counsel's dissertation regarding respondents' testimony must have a footnote dropped with a number of elements of salt in that she was not permitted to testify as an expert, and there was no expert to contradict the testimony of Dr. Hartman. So his testimony regarding the standard of care, in that testimony found, well, the ALJ found his testimony, Dr. Hartman's testimony, credible, and the panel members should also. His expert testimony indicated that respondent prescribed controlled substances in doses significantly above recommended levels. Respondent prescribed controlled substances in combinations that were dangerous to patients' health, combining stimulants and sedatives. Respondent did not properly monitor the patients on these dangerous drug regimens. She failed to do and document periodic reviews. Respondent did not have a treatment plan to wean the patients to lower doses or to taper them off the dangerous drug regimens. Her medical records were largely illegible. Her medical records did not include documentation of informed consent. As to the course of the investigation that brought this case forward, respondent ignored subpoenas from the board for patient records. She failed to comply with a Superior Court order to produce the records until she was served with a bench warrant for her arrest. She failed to produce records in compliance with a court order. They were all mixed together and illegible. According to the investigator, it was the worst compliance she had seen with a subpoena in 17 years. Respondent only produced compliant records 2 months after the court ordered her to do that. And beyond that, she added new notes to the records that she did produce. And subsequent to that, she failed to appear for an interview with the board when subpoenaed to do so. As to some of the statements made by respondent in her defense, she testified that her illegible records were legible and that they were for her use only. That's clearly contrary to the law. On the other hand, she testified that her illegibility was her best weapon to protect her patient's privacy. Board panel members can take a look at respondents' records in Exhibits 7, 8, 9, 10, and 11 and judge their legibility for themselves. She testified that the standard of care is different in private practice than in institutional settings. That is clearly wrong, as the ALJ noted. She testified that she did not have to document patient consent in her records. Again, that was clearly contrary to the standard of care as established in this hearing. She testified as to one patient that the patient was smart, organized, and successful, so she allowed that patient to determine what drugs to use, and she kept no records of the drugs that he did use. This is all contrary to the standard of care, which of course requires a physician to control the patient's medications, not to subcontract that out to an unlicensed individual. She testified she was unaware of a change in FDA policy regarding lower doses of Ambien, thereby shirking her responsibility as a prescriber. She believed she needed patient consent to comply with the Superior Court order, clearly wrong as reflected in numerous court cases. So what does this trifecta of adverse evidence indicate? Respondent is an exceedingly poor candidate for probation. She practiced by her own personal standards of care. She expressed no remorse. She demonstrated no recognition of the appropriate standards of care. She flouted a court order. She obstructed the board's legitimate investigation of her practice. She claimed the literature she produced at the hearing supported her treatment when in fact it did not. All of these circumstances coalesce in the conclusion that respondent lacks credibility. She lacks the necessary traits that responsible physicians must have: honesty and trustworthiness. These are not matters that can be instilled in a probationer through coursework. We therefore submit that revocation is the only remedy that will provide the public protection that is the board's paramount mandate. Thank you.
Thank you, Mr. Jones. Ms. Green, you have 5 minutes rebuttal.
Just, I want to address some of Mr. Jones's comments and respond to them. The board will note, if you look at the testimony with respect to Dr. Barton, is that there was a lengthy discussion about whether Dr. Barton could testify as to the standard of care, and the doctor allowed her to do so. Now, whether he treated her as an expert, that may be different. She is a treating physician, and the law with respect to civil cases and the like allows a physician to testify as to their understanding of the standard of care. With respect to this is a case that does not involve, there was no patient harm in any of these cases. 3 of the patients are still, at the time of the hearing, were still patients of Dr. Barton's. The claim that informed consent was not given, Dr. Barton testified that it was given orally. There was not a particular form, and it wasn't, but in those voluminous records, she wrote about that. She didn't necessarily just document it as informed consent, but she explains, it was her pattern and practice to explain each medication, what are the risks and the like. She's since changed that. When Mr. Jones says there's no remorse, she definitely had a regret and realized that her record keeping could be better. She knew that it was important, so she, obtained new forms, and did that. To say she ignored subpoenas is somewhat accurate, but if you look, she was guided by counsel the same time after the patients ordered that she not produce the records. With respect to her, this was not a case of honesty or dishonesty, and I don't think it should be characterized at that. Didn't see any case where there was an allegation of dishonesty or that she lacked credibility. With respect to the claim that Dr. Barton added notes, because the board investigator stated that the records were illegible, Dr. Barton went ahead and transcribed as best she could these very voluminous notes. In brackets, she would make a reference so that it had some context, or maybe explain an abbreviation she used. The judge asked us, counsel for Dr. Barton, to take the notes, the original notes, and to take the transcribed part, and to basically highlight and indicate which portions were added. And we did that. And when Dr. Barton testified, she was very clear about it. There was no fabricating of records. There was no attempt to make something look like it shouldn't be there. When we talk about the dangerous drugs, if you look at what drugs we're talking about, this is not, there were no pain medications. There were no opioids. These were psychiatric medications used on a regular basis for patients. When Mr. Jones mentioned this one patient who was smart, organized, and successful, we're talking about patient B. And during Dr. Barton's testimony, she had explained that there were a couple of different sleep medications that the patient would switch off of, and that because there were different prescriptions, and that he had a Fitbit where he tracked his sleep. He came in for psychotherapy. They discussed it. There was a plan. And it was written in the records, perhaps not like you'd have in an EMR, electronic record, but it was there. And gauging your patient's intelligence, ability to be compliant, following directions is something a judgment of a psychiatrist. And this,
Ms. Green,
yeah.
you have about a minute. Go ahead.
So I think it's a complete gross characterization and a total exaggeration to claim that Dr. Barton is not someone who's a candidate for probation. She certainly completed the other probation without any hiccups, any other problems. And in this case, I think if you read the testimony of Dr. Barton, you'll see that she was not arrogant. She was someone who acknowledged things she could have done better, and she showed extreme trustworthiness and honesty. You know, if the remorse wasn't what the board thought they wanted to hear, I mean, I think she acknowledged where she really could, and she is, I think, a strong candidate. Her training, her background, and everything that she has done over the past 30 years, and in addition, the way she comported herself at the hearing and her testimony, I think helps support that. And she also went ahead and took courses to show the board that she understood she could do things better. And this isn't an individual you need to teach honesty or integrity to. A record keeping can be taught, and she's made those changes. Doing better, careful documentation of the plan for prescribing can be done. And she worked with physicians and monitored these patients. She is not a danger to patient safety, and there was no credible evidence of that at all. So I would really urge this board to look at the records and before they make any rash decisions in terms of how they will respond.
Thank you, Ms. Green.
Thank you.
Mr. Jones, you have 5 minutes.
Thank you. Harm, no patient harm, it is claimed. Well, there is no requirement that complaint establish that any patients were harmed. The standard of care doesn't require that patients be harmed. One has to, the burden that the complainant has is show that the standard was not met and that the risk that created was potential harm to patients. And that certainly was well demonstrated in this case by complainant's expert, Dr. Hartman. The suggestion that respondent regrets what happened, well, certainly people regret when they were brought to task. The suggestion that she created new forms, that was brought forward during the hearing, but was not substantiated, and the ALJ did not credit that. And speaking of credibility, throughout the ALJ's decision, as you review it, there are numerous instances where he found, the ALJ did, that respondent simply was not credible and exercised a lack of judgment. So I don't think that, again, coursework that has been recommended is going to be sufficient to provide the necessary protection to the public. I would submit that based on all the circumstances, that revocation is indeed the appropriate remedy. And on that, I would submit the matter.
Thank you, Mr. Jones. Ms. Green, does Dr. Barton wish to address the penalty portion of the proposed decision?
Yes, and what I'm going to do is, because I only have one computer screen, I'm just going to have her sit there, and I will sit off camera.
Okay.
Okay, so if you just give us a minute here to make the change.
No problem. I'm going to follow her statement with questions from the panel. So keep that, if you can keep that set up, it would be good.
Will do.
Okay.
Okay, so have a seat.
Okay, there you are. Hi, this is Dr. Brooke Barton. I've been listening in on this.
Wait,
first of
Dr.
all,
Barton, wait.
Yes.
First of all, do you want to turn the camera back on?
Is it on?
Can you see her?
Now it is. Yes.
Okay,
Please
good.
raise your right hand. Please raise your right hand. Thank you. Do you solemnly swear or affirm under penalty of perjury that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. So you have 5 minutes to address the penalty portion of the proposed decision.
Okay. First of all, let me say that of these 4 patients, 3 out of the 4 patients are still in my practice and have been doing very well. I found that the medical board investigating this, I went back to a psychiatrist that I've used for therapy and supervision, Dr. Robert Ross. He testified at the trial, and I learned a lot from Dr. Ross. He's just great. And 3 out of the 4 patients, patient A, patient B, and patient C, are some of my favorite patients. They've done well. They're very high functioning. All these patients, when I did an initial evaluation, I spent 90 minutes, and all of these patients, their follow-up visits were 50 minutes. And most of them, MA is still in my practice, and she comes in once a week. All these patients, actually all 4 of them, had internists. Let's see, patient B, who had had sleep apnea, he had a sleep apnea specialist, and I corresponded with him and kept in contact. And the good news about patient B is that he got on a new sleep apnea kind of mask, and he's off all of his meds now, which is great. Patient A is retired, and she's on fewer meds. And patient C is just a great success. She was an attorney with the prosecutor of Los Angeles, and when she retired, she's pretty much off everything. I'm so pleased with her progress. And patient D, TS, is the one who actually was drug seeking from another doctor. And the day that I documented in progress notes that I wanted to reduce his Xanax, he never came back to me, and he was going to another doctor to get hundreds of Xanax. So I'm just as glad he left. In terms of the penalty portions, I don't know what to say. This isn't my field about that. But I can tell you that I've seen Dr. Robert Ross, who's a psychiatrist, and I knew him. He was a couple of years ahead of me in the residency at UCLA. Dr. Robert Ross has been, giving me supervision about these patients. He was trying to be an expert, and it just didn't go through with the legal whatever processes. And he's just a sweetheart, and he did come and testify for me. And he's just a prince. He's trying to help me get a COVID virus vaccine as we speak. But I counted up. I mean, I think that the patient A, I think I saw her in the course. I counted them up last night. I was rereading the notes. I think I saw her 550 times. Each one for all the evaluations were an hour and a half, and the rest of them were 50-minute evaluations. Patient MK came in once a month. He had a Fitbit and he had a computer phone, and he's a brilliant.
Dr. Green, before you get through all of your time, I would just want to remind you to focus on the imposed discipline, and if you want to comment to the board regarding that rather than the explanations. You still have about a minute and a half, so go ahead.
Okay, but I'm Dr. Barton, not Dr. Green.
I'm sorry. Your name is on the screen. I'm so sorry.
Okay. Yes, it's considering that all these patients had extremely well documented medications, the medication refills, all of this was well documented. And in almost every one of their appointments, their medication was discussed and how they were doing and side effects and were they doing better, they worse. I think that's about as good as we can get in medicine. And I'm doing my best. And I really think that revocation of license, of my license, it simply is inappropriate. And I think that you know, the judge was I liked him, and he got it. He had 8 days of testimony to understand what was going on. And I think that what he said about 3 days, 3 years of probation, I think it's appropriate. I mean, I just had my 67th birthday, and you know, I'm probably not even going to practice in 7 years from now. I'm going to retire. Anyway, I'll stop there.
Thank you, Dr. Barton. Okay. I'm going to move to panel questions. So, Dr. Lewis, I don't know if you want to call this or if you want to. I'm happy to go through the list. You go ahead.
I'm going to go through the list in reverse alphabetical order to give Mr. Watkins a chance first. So, Mr. Watkins, would you like to comment to either the attorney or Dr. Barton?
Yes, I'll direct my questions to Dr. Barton directly. Good afternoon, Dr. Barton. Can you hear me? Good afternoon. Well, that was certainly different than what I usually see. My first question is, when it came, when this hearing began, why did you preemptively do the prescribing course and the record keeping course with PACE?
Well, I was meeting with Dr. Robert Ross approximately once a week for supervision and psychotherapy, and he suggested it. So I thought, why not?
And the reason why I'm asking that particular question is because back in 2001, since this is not the first time you've been before the board, back in 2001, there was a stipulated settlement reached between you and the board. And there was also, the circumstances are similar to what we are facing right now, with prescription, giving the patients, you know, the flexibility and the discretion to use medications as per their discretion, right? And in that, sorry?
No,
It's not the same.
no.
Well, okay. Can you explain how it is different?
Okay. Well, first of all, wait, let me just get some water. Okay. First of all, the patient in 99 was in my practice for 10 years, and I saw her once a week. And we worked in conjunction to determine that she had treatment-resistant what they call mixed migraine headaches. And at the time, it was okay for doctors to prescribe psychiatrists to prescribe codeine preparations for doctors. And actually, the medication I gave her, sorry, I didn't know about expert witnesses at the time, but that was the codeine preparations I gave her. It was the exact standard of practice for mixed migraine headaches that are resistant to everything. Go ahead.
Well, where the pattern is the same is that multiple prescriptions with no formal of how.
Sorry, no multiple what?
No formal direction as to how those prescription drugs would be used. It would be discretionary on the part of the patient. It's like having patient autonomy.
No.
So the record is wrong in having captured that.
No. Dr. Hartman was limited, that he didn't have, last night I reread, I don't know, 1,000 pages of progress notes that I wrote on these 4 patients. he did not, he said that he couldn't read my handwriting. I've got Catholic girls' handwriting, and I can read it just fine. And I wasn't, most of it, I was not reading the type, I was reading the handwriting. This was all.
Oh, I'm sorry.
In conjunction.
Wait, we need to, whoever has the barking dog, it needs to be removed, or you need to mute.
Let me just get it to calm down while Dr. Barton can gather thoughts as well.
Okay. Okay, and Mr. Watkins, I just want to remind you that the panel's questions here, we need to focus on what is the question that is before the panel today. I just want you to keep that in mind, and Dr. Barton.
It's in the kitchen, just pick it up. Oh, it's right here.
Dr. Barton, do you recall Mr. Watkins' question?
Could he please repeat it?
So I am referring to in the record we have in the 2001 case where you reached a stipulated settlement with the board that you did education course and a prescribing course, and the reason why that was prescribed, and 2 years probation, and the reason why that was prescribed because the patient in that case was being given the autonomy to use multiple prescription medications as per their discretion with no direct guidance from you. And how that relates to today's case is that in the patient B, a similar trend was taking place.
I would disagree. Oh, I'm sorry. I would disagree with that. First of all, both the patient in 2001, I believe that the medical board's beef was not so much that I allowed her to alternate medications. It was that I was giving her codeine for her headaches, for treatment-resistant headaches, which was actually the standard of practice. It still is the standard of practice. Now, in patient, in patient B as in boy, in the current case, he had had a history. He had had insomnia since he was like 10 years old, and it ran in the family with depression and anxiety. And before he met me, he had had a diagnosis of sleep apnea, and he also was alternating sleep medications. And by alternating and mixing and matching sleep medications, particularly ones that were addicting versus non-addicting, he ended up on a lower dose of the medications. So I simply continued, with knowledge of him, what he found that was helpful for him. He was a very informed patient. He used a Fitbit. He used a phone. He came in for the entire time of the course of treatment once a month for a 50-minute appointment, and we would discuss what he was doing and go into vivid details. And again, Dr. Hartman did not look at my progress notes. So he did not have the luxury of seeing that we went into exhaustive detail about how he took and what did this and what did that, and over time. And this fellow, when he finally, and this was done in conjunction with his sleep apnea specialist, Dr. Zakarian, who's a pulmonary specialist. And the good news is that it just towards the end of the treatment, which is documented in the progress notes, Dr. Zakarian and the powers that be came up with a better sleep apnea instrument for him. So he's off all sleep meds, which is great. I'm delighted.
So you mentioned, this is my final question. So you mentioned that you see Dr. Robert Ross and he's a darling and sweetheart. Is in a 1999 case, the board also compelled you to take a mental exam, and in that, compelling you to take a mental exam, and that was conducted back in 2000, May of the 3rd, 2000, by Dr. Jacks, and he discovered some disorders, and he suggested that you take up psychotherapy. That was part of that order in 2000. And I just want to understand if you are still under psychiatric treatment with Dr. Ross. Is that what that
Yes.
refers to?
Yes, I just had a session with him. I think it was Monday night of this week.
Okay. Well, thank you.
Okay.
I'm sorry, let me just finish, which is that I had been seeing people for supervision and psychotherapy for long before the medical board made that. That's pretty common in psychiatry to do that.
Okay, thank you, Dr. Barton. We're going to move on to Dr. Tirado. Do you have any comments or questions?
No, thank you.
Okay, thank you. Next, we'll move on to Ms. Lubiano. Do you have any questions of Dr. Barton or the attorneys?
Yes, I have a question to follow up on what Attorney Green had mentioned earlier.
Okay, so you want Attorney Green back on screen?
Okay, here I am.
Good.
Hi, thank you.
Go ahead.
Attorney Green, you had mentioned that there were several places in the record that pointed to doctor's decision not to compel the documents, particularly because of the advice of counsel. Can you point me to those areas or summarize the reasons why? I mean, I noticed how some of the patients had, didn't give consent, but just looking for a little bit more information there.
No, I couldn't hear anything she said.
With respect to on the order, I'm just looking at which exhibit numbers there are. I think it would have been in complainant's exhibit 20 and 21, which set forth, and I think that's in complainant's exhibits. And with respect to respondent's exhibits, we produced the letters from the patients and or their attorneys. Also produced are the briefs that were filed. And you can see that from my point of view, what I saw, they were certainly meritorious. I mean, it was not a frivolous argument, and there were some real legal issues there. So, and that's I don't have which exhibit, like I said, complainant produced all the records in the petition, and in respondents, we produced exhibits that that basically were in response and what was filed by Dr. Barton's attorney. Now, this is a case where she followed the advice of her attorney, and so this was, that's another, she was doing it because she also didn't want to get sued by her patient. She was sort of stuck between a rock and a hard place. And then with a court order, certainly the patient could not object. And actually, they were given time to object if they wanted to appeal, and they did not.
Got it. Thank you very much.
Okay,
no further
thank
questions.
you. Thank you. Dr. Hawkins, do you have any questions for either attorneys or for Dr. Barton?
Yes, I just have a few questions for Dr. Barton. Can you hear me, Dr. Barton?
Yes, she can hear you.
So, Dr. Barton, you indicated that and actually your lawyer indicated that you took a prescribing practice course and a medical record keeping course. And that may have happened in part because it was recommended by a colleague or mentor. Do you know what a ethics or professionalism course is? You ever heard of that before?
Yes.
Did you take that course, or do you think that would have been of any benefit in these circumstances?
I haven't taken that course at UCSD PACE program, but I certainly have done continuing medical education at the APA annual meetings. and one of the subjects that they talk about is ethics and medical professionalism.
Okay. And so the last question is, and perhaps being brief, unless you need to expand at length, in what way has your practice changed since you've taken the prescribing practice course and the medical record keeping course?
Well, one thing is that I now give anybody who is a new evaluation or an ongoing, I have them sign and date anything they take from me, whether it's an addicting drug, habituating drug or non-habituating drug. They have to sign in writing and date that they agree to take it.
Is that it?
No, and also I do written documentation of risks, benefits, side effects, which of course I had done in frankly all of these cases. It's all in the medical records. It's just that Dr. Hartman didn't have the luxury or couldn't read my handwriting of seeing that it's documented all through the medical records. So I've continued doing that. So I write very, very exhaustive records that have to do with what's going on with the person's life, the process notes, and also the side effects, and what are the problems. For example, I'm going to stop there. I'm derailing from what you asked.
Any other changes?
I'm sorry?
Yeah.
Any other changes like record keeping or anything?
Well, the record keeping, it's very important. One of the things that I learned when I was in supervision with, at any time, 5 different supervisors for an hour a week each, so that's 5 hours a week during my residency at UCLA, is that you got to keep track of a couple of things when you do progress notes as a psychiatrist. One is you want to keep track of what the patient's telling you and what does it mean. And when you write it down, that sort of helps you process it. But you also want to document what they're taking in terms of medication, and are they doing well on it? Are they having problems? Are they having side effects? What else is going on in their life? And this is documented up the wazoo in these. For example, in patient C, who was probably the sickest of all these people. She was maybe high functioning prosecutor for LA County. She's now retired. And she had a really scary depression. And she had spent most of her life in this depression where she was just barely hanging on by a thread at her job. And, for example, when she was upset about her brother who had Asperger's, and she had 5 car accidents with head-on collisions on the 405 freeway. Woo! Not related to the medication, but just because she didn't pay attention. And even in her initial evaluation, she said, "When I get upset, I don't pay attention on the road." Her friends would not allow her to drive them.
Dr. Barton, I apologize for interrupting you. You mentioned a couple of different things that you think are important to document. Are you saying that you document those in the medical record?
Oh, yes.
Okay, and then and even though you have a Catholic girl's handwriting, there was some difficulty. Do you transcribe medical records now or no?
No, what I try to do is I try to do my medical records when I haven't had a cup of coffee. It's a family thing. My father has the same thing, where if we have a cup of tea or a cup of coffee, it's very hard to read. So I try to write all my notes when I haven't had any tea or coffee.
Okay, well, thank you very much.
Thank you.
Okay, thank you, Dr. Hawkins. Dr. Yee, do you have any questions of either attorney or Dr. Barton?
Yes, Dr. Barton. My question is along the line, Dr. Hawkins. I get most of the answers that whether you know anything from this whole process, from the causes, in order to change your practice. I get it, you're not dictating your notes or transcribing for one. Have you learned anything, change your practice, whether using different medication or more updated medication, the way you're treating your patient? Do you feel this whole process that you have gained some knowledge as well changing your practice?
First of all, right now, remember, right now we're in the COVID virus, and I actually was ill most of this last year with the COVID virus. First of all, honestly, in the last year, In 2020, I only saw one new patient. And part of that was that I was afraid to see a new patient because it's only on the phone, because I didn't want to give someone the bug and I didn't want to get the bug. So when you only see one patient in a year, you don't need to transcribe your notes. And I can read the notes, and they falsely testified something about that I only write my notes for myself. First of all, doctors don't want my notes when someone takes over the practice. What they want is a summary, and I always write the summary typewritten and have the patient check it and make sure they think it's accurate. If they want the actual notes, I'll give it to them. But most of the time, and I'd say 95% of the time, they don't even want my notes. The practice has changed. And you know, if you have a high volume practice where you see 40 patients a day, you could transcribe notes, you can do electronic files. But I have been very leery about electronic files because when you have something in the ether, people can tap into that and listen to it. And when I keep a paper copy in my practice, it keeps that person's their file safe so that they can know that they come to me and it doesn't go anywhere. I'm very concerned about that with electronic files.
Thank you.
Okay, I have a couple questions. Mr. Jones, are you on the screen? I can ask you a couple questions.
Certainly.
Okay. Now, from what I understand, and you also said, this complaint is based, or this issue is based on one complaint. Is that true?
Well,
I'm curious because
medical board investigations often commence with a single complaint. It provides the board an opportunity to take a better look at the practice of the physician. And in that process, for example, the cures reports may be reviewed by the medical consultant in the district office to determine whether there may be other patients who may, on appearance in the cures report, be receiving inappropriate prescribing. So that's a very common practice. And it's supported by the case law. The California Supreme Court in the Lewis case said that was totally appropriate. So
yes, but let me interrupt you. So you or the complainant identified other cases in cures, but may have nothing to do with the incident case. But when we look back in cures, somebody in that office identified other potential problems. Is that how I'm understanding it?
yes, actually, the medical consultant for the board in Sacramento, Dr. Nuovo, saw 2 other patients, and I believe a medical consultant in Glendale also identified another patient. So there were a total of 4 patients in the case.
Okay. Are you the original DAG in the case, or are you filling in? I couldn't remember.
I'm filling in.
Okay, so you weren't there for the original hearing.
That's correct.
Okay, just to be clear on that. Now, the complainant's expert is familiar with polypharmacy in the psychiatric field. I couldn't see that.
And that's my understanding, that based on his testimony and his curriculum vitae, that he treats patients in multiple capacities, including pharmacologically.
Okay. Now I'm going to move on to Dr. Barton. Dr. Barton, hi.
Hi.
What is your postgraduate education? I'm sure it's in the record, but 1,000-some pages, I can't remember.
Okay, well, I'm not sure. So I graduated from Princeton University in biochemistry and got with honors, and then I went to Columbia Medical School for 4 years, and then I came to UCLA for internship and residency. And the internship was what they call, at the time they called it a medical categorical star, which was, oh boy, it was great. Wadsworth VA was such a great education. And then that was, so the Wadsworth VA was where I did my internship. And then I did 3 years of residency at UCLA, and I was chief resident of outpatient psychiatry in my 3rd year. And then after that, I don't know if you count this as, but I supervised residents and taught them as a volunteer for 20 years at UCLA.
And this particular incident, if I'll call it an incident, occurred at what institution? Private practice, or were you a member of a medical center?
No, I'm all private outpatient practice. When I first went out into into private practice, I did a combination. I worked at, oh, it was great. I worked at all of you, the medical center, the emergency room, and also in their wards. And I also was on staff at St. John's Hospital in Santa Monica for 10 years doing inpatient and consultation liaison. But they currently, like a lot of psychiatrists, when you've been doing that for about 10 years, you want to be able to sleep through the night. So I switched to, I also switched to exclusively outpatient practice because I joined a group practice, well, not group practice, but we shared office spaces. Excuse me.
Okay.
And those guys, they didn't want to have to get woken up at night.
Okay, I think I have no further questions. The question about the EMR and your very small practice was already previously answered, but you do everything still by handwritten notes.
Unless somebody wants a typewritten summary, and I type. I'm a touch typer.
Okay. Yes. Okay, thank you for your answering my questions, and also to Mr. Jones. Okay, with no further questions or comments, I'm just going to make sure, I'm just talking about panel members. Any further comments or questions before we move on to the closing statements? Okay, seeing none, I'll turn it back over to Judge Rowan.
Thank you, Dr. Lewis. So we did the opening statements. We had 5 minutes for rebuttal, and we had questions for Dr. Barton. So that will conclude today's hearing. Well, let's see, Ms. Watford. The record is closed. The matter is submitted. We are now off the record.
Okay.
Thank you.
Thank you, everyone.
Thank you all.
Dr. Barton, I really appreciate all the time and energy and effort that you've put into this.
Thank you.
Thanks. Okay.
Ms. Watford, can I get the ending time and estimated pages?
Yes, ending time is 1:44. Estimated pages is 50. 50, sorry.
Thank you. Got it. Thank you. Okay, so I believe that's the last of the board hearings. Ms. Watford, is there anything that we need to clarify before you go?
I don't know if Mr. Jones is still on the line. I was going to ask him what DAG office he was out of. Do you know by any chance? Is it LA?
He is already exited.
Sorry, please repeat.
Mr. Jones already left.
Oh, okay, no problem. I can find him online. I just couldn't remember what office he was out of. Thank you so much.
He's out of LA County.
Oh, perfect. Thank you so much. That was all I needed.
Okay.
Okay, great. So that concludes the hearings. And Ms. Watford, thank you so much for your help today and your patience. We will see you next time.
All right, I'm going to exit right now. Thank you, everyone.
Thanks.
Thank you.
And Dr. Lewis, I'm going to mute and give control back to you.
Okay, we're going to wait till the room is vacated,
Dr. Lewis, actually, at this point, all the panelists should exit the meeting.
Oh, we have to exit and go back into another WebEx, which is
Yeah,
in your email.
So you've received a separate invite, one with a closed session that says deliberations at the end of it. So please leave this meeting and head over there. I'll meet you there and get you started over there.
Okay, we exit now. Okay, thank you.
For the public attendees, still joining, you're welcome to stay in this open session meeting for adjournment at the end of the deliberation period, but that concludes the oral arguments for the day. Okay, everyone, closed session is ended now, and the board members will be coming back to dismiss the meeting shortly.
Okay, tell me when you're ready, when you've opened up the doors.
The public members that have been waiting are still here. We have 4 board members in. We're waiting on Dr. Yip and we got Mr. Watkins.
We have a quorum, so we can close it out.
Okay, so we're now open in open session for panel A, and we will now undergo adjournment. Thank you, everybody, for your participation. And 7.5 hours. So it's been good discussion. So thank you very much, and the meeting will now adjourn.
Thank you.
Thank you. Have a good evening. See you tomorrow.
See you tomorrow.